Deidre. Hey, Ms. Melvin. How are you?
I'm good. How are you?
Good to see you.
Nice to see you too.
I left all day. So. God bless you.
That's what.
That's it. Look at that. Oh, yeah. Easter eggs. We start together.
For to all mean nothing. I'm just kidding.
No, how are you?
Good.
Oh, you don't. But I need to please.
They look good.
Okay.
Thank you.
And you're gonna get started.
Thank you.
Okay.
All right. Good morning, everyone. Want to figure out what we're doing today and not doing today. So the Talbot case, Ms. Smith, you are dismissing.
Yeah, sure.
Okay. I don't think you sent something. I don't think you need to unless you want to. You can simply move to null pros and we can stamp the indictment. But it may be that you're required to. You sent a remarkably thorough null pros document on the Green case. I now understand a whole lot more why that's not a trial. But Talbot, I didn't see anything yet. Are you planning on it or are you simply moving to null pros and we'll stamp the indictment?
I'm moving to North.
I think we can.
You may have already done it.
Okay.
Okay, I wanted to, I didn't want to jump ahead of things because Ms. Smith sent this book about the Green case. I don't mean that critically. It was fascinating to read how that case was put together and what you all had to deal with, and Ms. Green had to deal with. All right, so the CSX rail car or cargo unit burglary case is officially closed. Mr. Oliver is supposed to be here. Okay, you'll reach out to him?
I'm trying to.
Okay. This is the same guy who played hard to reach with you, and so he didn't know a lot about the case. And okay, all right. Well, we'll give him a little while to get here. But what I'm understanding is state came up with a new offer, and he's accepted it.
I spoke to him on Friday afternoon. He was ready to plead and told me he'd be here this morning.
Okay. Mr. DeKnight, as I understand it, both sides agree that that's not a case we can fit in the window we have. But both sides are ready, so we could have it be a high priority for next available calendar, which I think would be beginning of the new year. Although I may be trying to push another one that you both are on, the three, they're not all Jew, but I think two of them are brothers. Yeah, that one. But the Nike and that one are at the tippy top. I'll bring him out and talk to him about that. I assume we have DeKnight here and we have Mendez here. Okay. So we can get on the record that you can get on the record your concerns and you can get on your opposition or we agree that it would take this long and it won't fit in that window. But I don't want to bring him out if it's a different outcome than what the email traffic had been. Same? Okay. All right.
You want, obviously, if you want, you can do whatever you want, but for, we could put it on as a backup to December 1st or, whatever, if the court wanted to do that, just in case there were any issues or that arose, or we could put it first out.
I very much want to not try what we're trying on December 1st, but we have to. And it just doesn't work on the Emerson calendar, so it's going to be here. I'm trying to remember, we have Hairston as a backup, but I don't know what Banks is going to say on that. And then the other backup is also not one of your cases. It's not yours either. It's the one where Carrie.
No, Ontario's right.
Yeah, no, it's not. It's Wright is the last name, and it's yeah, and there's a private attorney, and I think it's Ms. Willingham. It's the person, this woman who the defense is somehow she was able to shoot herself in the head in like a physically difficult way.
Back of a car.
Yeah. I think those two I put as backups. I'm happy to have tonight. I don't want to leave people hanging. You've got to be ready for something anyway. What's your thought about that? You want to just, do you want it as a, hey, maybe we would reach it if the pool case doesn't go, or move it to January? I don't want to raise his hopes because it would be a backup. I don't think Hairston will be a trial. I don't know about the other one, right?
I don't know. I just need to talk with the family to make sure they'll be here, but I think, yeah, sure.
Family is not local?
No, like, I don't know, holiday plans with people, but I guess it's not really close to Christmas.
No, it is not. It is the very first week of December. It is December 1 through 5.
Yeah.
We'll have it as a backup.
Okay.
Okay. All right. I'll explain that.
December 1st?
Yeah. I mean, the lawyers all know this now, so they've got notice. You don't need to publish a new calendar. You can do a supplement if you want, but there's several layers to that one. Then Ms. Green's case, I've signed the null pros. I don't know if it hit the docket yet, but I signed it yesterday after I read it all. And then I got it to Ms. Nelson, so that should be taken care of. And let her know that Ms. Green didn't need to be here. Hopefully you got that word.
Yes, but then I also drafted up a proposed order to seal. I don't know if we'll be fine to sign that from the screen.
I wouldn't be opposed. I think I got that. Did you send it directly or would I have received it through Ms. Nelson? Yep, I've got it. So I'll take care of that this week.
Thank you.
You bet. Hi,
Hello, good morning, Judge.
good morning. That gets us to Mendez. Let's talk about that before we bring him out. We'll actually bring Mr. Denike out first to chat with him as to what we're doing with the Mendez case. And I did receive a motion to continue, I think it was yesterday, because somehow the state didn't learn until late Monday that the lead detective is on vacation. And that's where we are. So, Ms. Williams, if you want to, well, we should have Mr. Mendez out here if we're going to get stuff on the record. Anything more you want to share about that before we bring him out to talk about it?
Yes, Judge, and just preliminarily, and I'll of course restate this when Mr. Mendez is here. Yesterday I was out in the field investigating the case, spoke with several witnesses that no one had been able to speak with before. And so thank you for your patience yesterday and this morning. Based on the information that I've received and the witnesses that I spoke with, I do not believe that based on the indictment that the state has, we will be able to move forward. So I believe it's my responsibility at this point to dismiss the case.
Meaning you may re-indict, or based on your investigation and the people you've contacted over the last few days, it's not a set of charges that the state's going to go forward with, full stop?
I don't think I'm in a position to have the last word on that, but from what I understand, I do not believe that the state will be moving forward on the charges.
Okay. And I press you on that, not to reveal any state secrets, but we'll get all this on the record. It'll make for a shorter conversation. I'm understand that Mr. Mendez has an ICE hold. And so if you move to dismiss, and I grant it, I won't oppose it, we just need to understand that he may then slip from the state's grasp because there won't be a no bond situation anymore for those charges. He's not going to suddenly be running around in the streets. He just would likely not be amenable to prosecution for a while because he'd be removed from the country.
Yes, no, oh, I understand what you're saying now, Judge. As of right now, I'm not preparing a re-indictment or re-accusation or anything like that.
Okay, and you are free to pursue what you think your office thinks makes the most sense. It's just that Mr. Mendez, likely won't stay, and certainly if you dismiss the charges, the no bond status goes away because there are no charges, but there is an ICE hold, and so they'll be contacted, and if recent history is a guide, he will not be here very long. And that will just make it more difficult if your plan was, well, but in 10 days, we're going to do X. Okay, understood. I appreciate the work that you have put into this now, rather than 258 days ago, but it wasn't your case 258 days ago.
Thank you, Judge.
Ms. Wood, anything you want to talk about Mr. Mendez's case before we bring him out? All right, because we've got an interpreter here, a translator, I think we'll do that first. But before we do even that, we have Mr. Richardson here. Good morning, sir. I am well. I appreciate you on short notice making time to be here. Is your client planning on being here? It's all good. I just wanted to make sure because this was kind of last minute-ish. Both unfortunately, she didn't get diversion, and then, hey, a window has opened up today if it's going to be a trial. So thank you for being here. And we'll wait for her to get here. So my thought is we bring Mr. Mendez out. All right. You do. For a guy who's retired, you have to be in a lot of courtrooms. I'm just saying.
This is one of my favorite things.
Okay.
It's one of the things that's not.
All right. You go see Judge Dunaway. Ms. Feely, you're here. That doesn't always mean good things. Everything all right?
Always looking for excuses to make.
Okay.
I was just getting one of the jury selection role this morning, finding YouTube.
Excellent.
Oh. Before they run, can I go to the ladies' room? I'm sorry.
Sure.
I'll have to,
If you want to go into the jury room, it's closer. It's right here. Okay.
I'm gonna put this equipment right here. I just don't want to. I'm sorry, it's just this, sorry.
You're right.
Yeah.
The jury room.
Jury room. If you push or pull, there's a door right there. Yeah, it's a hidden door. And then to your right is a hidden room, and there are 2 hidden bathrooms in it. Ms. Wood, you and Mr. Mendez Carranza can sit at council table if you want. I think you have to be at the podium for this.
Estoy en sala,
Hi there. We have another interpreter here. We only need one. You want to arm wrestle?
Well, I heard it's the trial.
It's now not going to be a trial.
Gotcha. If it was gonna be a trial, then the coordinate with us would be tag team.
Oh, definitely. If it was going to be a trial, we might need Quattro. But we're good because it's just going to be a short conversation. And she was just using the restroom. In fact, here she comes.
Fantastic. Okay, and if it works, I'll come in so we could both get sworn in. and I could just tag team in and out.
Right, no, and that was the plan, if we were gonna, thank you for being available, but we'll make sure Tanja or whomever knows, no trial, and so it's just gonna be a fairly quick conversation.
Thank you.
All right,
Have a good one.
thank you, you too.
Sorry, the worst time.
Are you ready? Okay, I'll swear you in. Do you swear or affirm that you shall translate faithfully and to the best of your ability from English to Spanish and Spanish to English?
I do.
Great,
For the record, I'm Marcela Romero Langua, licensed certified court interpreter.
Great.
I will give the spelling of my name.
that's okay. We're not on the record for this conversation. I just need you to help out. We've got a lot of legal firepower in the room today. When we were actually going to trial, we struggled to get lawyers. Here we've got half the major case unit. We got Ms. Williams, got this senior PD supervisor. Okay,
¿Me oye? Subir el volumen. ¿Me escuchan?
is it working?
Yes, sir.
Okay.
¿Me escucha bien?
Sí.
Good morning, Mr. Mendez. Your lawyer and the prosecutor and I have been talking about your case. The prosecution was working very hard over the last few days to speak with witnesses who had information about you and your daughter and the allegations in the case. And the state has, meaning the prosecution, has decided to dismiss the charges against you. That means no trial. It also means that these charges will no longer hold you in jail. But if other agencies have a hold on you, then you will be transferred to their custody. Do you have any questions about any of that?
Como si no lo entendí muy bien.
I'm sorry. Puede, no le quítese diga.
No lo entendí muy bien que dijo de la custodia. ¿Qué dijo?
What did he say? I didn't understand about the custody.
So, Mr. Mendez, you have no bond on these charges, meaning you are going to stay in jail until the charges were resolved. You go to trial or you plead guilty, or the state dismisses the charges. The state is dismissing the charges. So these charges will no longer keep you in jail. But it is my understanding that Immigration and Custom Enforcement has put a hold on you, meaning they have provided paperwork that tells the sheriff to let the sheriff know when your case here is done, which it now is, so that ICE can come get you. So I think, but I don't know for sure, that you will go from the county jail into some facility that ICE runs. But again, I'm not telling you for sure that's what will happen. I expect that's what will happen. It's also possible that the sheriff will simply say, you are free to go. And you walk out of the jail.
salga de la cárcel.
Did that answer your question?
¿Eso responde la pregunta que usted tenía?
Sí.
Yes.
Do you have any other questions for me?
¿Tiene alguna otra pregunta que hacerme a mí?
No, gracias.
No, thank you.
Okay, well, you're welcome. I didn't do much other than push to get you to trial.
Empujé para que se llegara a su juicio.
You should thank Ms. Wood,
Dele gracias a la señora Wood
and you should thank,
y dele gracias
okay, and you should thank Ms. Williams,
a la señora Williams,
the prosecutor recently assigned to the case.
recientemente asignada al caso. Thank you.
Everyone's been thanked. Okay, for getting down to the bottom of the allegations. All right, well, if you have no other questions, Mr. Mendez, I'm gonna have you go back with the sheriff's people.
Thank you. Thank you. Thank you.
De nada.
If there is no further business, Your Honor, may I please?
You did a great job. Thank you so much.
No.
All in a day's work. Ms. Williams, does Ms. Nelson have your cell phone number?
Absolutely, Your Honor. I believe I can update. Do you have my personal? I can give you my personal cell phone as well.
I'm not sure which one I called this, but I did get you.
I'll
As
send
long
you-
as she's got digits that work for you, we're good.
Yes.
Okay,
I'll send you both of my numbers.
all right. I think Mr. Oliver is here now. He is. So you can chat with him while we bring Mr. Denike out. Please.
I do have the dreaded paperwork.
I don't dread it. I'm happy to sign it. You can come on up with it.
Only have to do one signature.
Right.
6 pages for every copy.
Right.
But I'll get it.
Ms. Smith, I don't see Mr. Miller here. Will you be handling Dawson, or Mr. Miller will get here to handle Dawson?
I'll do the two first.
You'll do it. Okay. Hey, Mr. Denike, if you come on up to the podium, please. Good morning, Ms. Rivers.
Good morning.
We're going to get on the record for this one. It's 25 SC 002 969, State versus Denike. Mr. Denike is here in court with his lawyer, Ms. Rios, and we have Mr. Abadi from the state. And Mr. Denike, when I last saw you, I told you, hey, we are gearing up to go to trial in your case. And the lawyers, after that conversation, went and started seriously preparing for everything. In the course of that, the prosecution reassessed how long it would take to present all the evidence in your case. And it does not look like we could, today, all we would be doing is picking a jury. It takes a whole day to pick a jury. So that leaves us Thursday, Friday, and then realistically Monday, Tuesday of next week, because then we start hitting Thanksgiving and we lose jurors. And I'm going to let the prosecutor speak for himself. He does that well. But he has filed a motion saying, Judge, we can't fit the case into that 4-day window. And we could always tell the jurors, go home and we'll see you in 4 or 5 days, except I have a specially set trial that next week. So we actually would be telling the jurors, you got to go away for 2 weeks and come back and try to remember what we've been talking about. And that is not always advantageous for a defendant. And so my understanding, but your lawyer will speak for herself also, is that she's not real comfortable with a plan where we do some of the trial and then we take 2 weeks off and then we do the rest of the trial. And so I'm going to tell you a little bit more about what I think the plan is going to be, but I'm going to let the two lawyers lay out what they need to lay out. Okay, Mr. Abadi, if you want to set forth the state's, you already have a written motion, but if you want to get anything more on the record with Ms. Rivers.
Yes, Judge, and I think you stated it pretty perfectly in the sense that in assessing the case and identifying and locating all of the witnesses, especially the lay witnesses, I think that we would go over into Wednesday and potentially into the following Monday, which we would be unable to do because of the special set. So based on that assessment, that's when I reached out to co-counsel and the court.
Okay, got it. Ms. Rios, your thoughts about how best to manage this? Do you oppose moving it?
Do not oppose, of course, we're ready, but yeah, I don't think it makes sense to split it and come back.
Okay. Mr. Danaik, I don't like leaving you unsure of what's next, but there are two scenarios. I mentioned that there is a specially set trial that's supposed to start on December 1. If for some reason that falls apart, your lawyer has said, hey, we're ready, we'll jump in and be the case that you try that week. And it's Mr. Abadi is the prosecutor on both cases. So if his other case goes away, he'll be ready to do yours. So a possibility is that we would do it the week of December 1. I don't think that other case is going to go away, but if it does, then we could try your case. Assuming on December 1, I try that other case, then we'll put you on the January calendar. There's a calendar every month, so it's not like, hey, I'll see you in June of next year. And I'll keep pushing yours up towards the top because I've got lawyers who are ready on both sides. The state has located the witnesses they need to. Ms. Rios is ready to advance your case. And so there's no reason not to try it. And there's a lot of reason to try it because you're sitting in jail. And you're entitled to a day in court for that. Does that make sense, what I described?
Yes, sir.
Okay, do you have any questions about any of that?
Yes, sir.
What's your question?
You said if we wasn't ready for trial today, that we could discuss bond.
Okay, I did say that. What I said, the full thing of what I said was that if we don't go forward today because the state says we're not ready, we're still looking for Fred Jones, or there was this concern about the ballistics evidence. And the state has, the DA's office has tried very hard to get it, but another part of the state had been moving kind of slowly, but they got that evidence. And so we're not going forward, not because the state's not ready, but because of the way the calendar works. And so I don't feel like I'm going back on my word. We could start today. I just don't think it would be an ideal structure for you and for the jurors because there'd be that 2-week break in there. So I'm gonna not talk about bond today. But if we are able to go on December 1, or let's say it's the early January date, and the state said, oh, well, you know what, we're actually not ready now, we can't go forward now, then we do exactly what you said. Well, state, you need to be ready. Mr. Danaik is ready. He's the one sitting in jail. No one else is. And so if you hear state saying not ready, then you tug on Ms. Rios' sleeve and say, hey, we should talk about bond. Okay?
Yes, sir.
All right. Ms. Rios, anything else on behalf of your client?
Yeah.
Thank you for your preparations. Mr. Abadi, anything else on behalf of the state?
I got nothing further from the state.
Okay. Thanks, everyone.
I'll let your mom know.
It's a new pen. It's like, it writes in metal. All right. Thank you.
Good to see you.
Same. Ms. Dawson?
Yes, sir.
How are you?
I'm doing good.
Good. Thanks for being here. Mr. Richardson is here. He went to another courtroom and he's going to be back. He checked in, told me you were getting your kids to school. So we're going to take care of your case. If you don't mind sitting tight when he gets in here, we will get going on that. We have one other plea that we might start if Mr. Richardson's not here. But the only two things this morning are your case and this one other one. All right? Mr. Abadi. The pool case is what in theory we are doing starting on the 1st. how long do you think that trial will take with all of these experts now?
I think we would, at the latest, be done, I guess, the following Monday. That, to me, that seems to be that's the, I think we should be done by Friday, in my opinion, but I think Monday is the maximum we should take.
Okay, so, I am that Monday and Tuesday teaching the new judges orientation. There are only 3 new judges this year, so it's shorter. It's usually a 4-day thing, but Judge Burleson and I do that in Athens. So I've wedged it into a week. I will reach out to your opposing counsel to see if we could actually pick the jury on, Tuesday, the 25th, so a week from yesterday. All we do is jury selection. I'd have to move some stuff off that day. My staff attorney is going to be unhappy. But I had that day blocked out for Mendez or Denike, whatever we were going to do, assuming we can get defense counsel here. Any reason you couldn't pick a jury that day so that Monday morning we start with openings? Okay. I will reach out to him and try to make it sound as non-optional as possible. But I don't know, he may already have leave. If he cannot do that so that we pick a jury on the 1st, it would just mean that we would be bumping into what I wanted to avoid with Denike. You have that whole week, and I don't have drug court that week. So the whole week of the 1st, we'd be trying Poole. Is that his name? Yeah. But then we would not be able to resume again till Wednesday. I can't not do the NJO thing.
That's fine.
I mean, it's suboptimal, but at least he's out on bond.
That kind of works for the trooper schedules are interesting. They seem to be very important. They guard, the Speaker of the House.
Oh, right.
One of them's in Monaco, so.
Oh,
yeah.
Okay. But I think that's right. Like the Chief Justice has a bodyguard type, and I think that's a trooper. They do that. Okay.
That's not either. I had forgotten. I didn't even know who the Speaker of the House for Georgia was until.
Burns. Okay. Well, I want to make sure that worked for you. I'll reach out to, the defense attorney, Mr. Miller? Is that his name?
Yes.
Yeah, Mr. Miller. Okay. All right. That's it. Great. Ms. Wood, you just left.
Okay, sir, please, okay, she's gonna do something, but I'll be thinking of her.
Oh, is she all right?
Yeah, she's fine, she's gonna do that release thing.
Oh, right. Okay. Well, are you ready on the Oliver case?
I am.
Do you need to talk to Mr. Oliver? I thought she was talking with him.
Yeah, she's gonna talk with him, give me whatever, no.
Okay, so she's not ready yet on that.
No.
Okay.
1 second.
No, we're good. I heard that Ms. Rios is going to do you a solid and handle the Oliver plea so you can go be habeas witness. Okay, are we ready on Oliver?
We are ready and, just hand it over. Okay, thank you.
What did you supposedly do wrong in the habeas case?
Didn't explain the terms on the plea.
Is this a Carroll County case?
No, this is your case.
Who is it?
Michael White,
Hmm.
I think you would remember it, it's the, shot and blocked in front of the little girl, it was just Willingham.
Oh, yeah.
Yeah.
Huh, okay.
Yes.
Well, good luck.
Thank you. Oh, wait. There's a felony on there, that fire receiving.
Oh, okay.
Yeah.
Deputy Gordon, could you adjust the screen so we get more than Mr. Oliver's chin, please? There we go. Let me know, Ms. Smith, when you're ready to go.
I'm ready to go.
Okay. Ms. Rios, you good?
Yes, sir.
All right. So we're getting on the record in 25 SC 001734, State versus Oliver. Mr. Oliver is here in court with his lawyer, Ms. Rios, who is co-counsel with Ms. Wood. And we have Ms. Smith for the state. And Mr. Oliver, Ms. Wood sent me an email earlier this week saying that you and she had spoken, there was a different offer from the state, and you were prepared to go forward with a plea. Is that correct?
Yeah.
Okay. Ms. Smith is going to put you under oath in just a moment and then ask you a bunch of questions about your rights in this case. You need to answer those questions truthfully. You also need to let me know, or Ms. Rios, if you've got questions of your own. Will you do that?
All right.
Yep, okay, and make sure whatever the question is, you answer out loud and with yes or no, or maybe, or I don't know, and not or okay?
All right.
All right, Ms. Smith.
Mr. Oliver, can you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Elijah Osborne.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
I'm 20 and I graduated high school.
You're 20,
Yeah.
Where'd you go to high school?
Latin.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty today? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for purposes of this plea?
Yeah.
Mr. Oliver, do you remember being arrested for these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Attorney Rios?
No.
Mr. Oliver, do you understand that you are entering a guilty plea to the following offenses in indictment 25 SC 001734, count 1, theft by receiving stolen property, count 2, hit and run, duty of driver to stop or return to scene of accident, count 3, fleeing or attempting to elude a police officer, count 4, reckless driving, count 5, operating without lights required by law, count 6, failure to obey a stop sign, count 7, too fast for conditions, count 8, failure to obey signs or control devices, and count 9, driving without a valid license. Do you understand that those are the charges?
Yes.
Okay. Counsel, are you satisfied your client has a full understanding of this procedure?
Yes.
That is a duplicate page. Okay. Mr. Oliver, do you understand that this is a negotiated plea of guilty, which means you, through your attorney and the state, has reached an agreement on how this case should be resolved, and we will present that agreement to the court for their consideration?
Yes.
Do you understand that the state will be recommending a sentence to the court of 5 years probation, of 5 years to serve 30 balance probated?
Yes.
Are you also aware that the court does not have to accept their recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
That was 5 years to serve 30 days, you said?
5 years to serve 30 days.
Okay.
30.
Yes.
Okay.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance sentencing, including in a federal case?
Yes.
Are you currently on probation?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes.
For example, this could be your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to possess, receive, or transport a firearm, or the ability to maintain employment.
Yes.
Do you understand that by pleading guilty to a felony, You cannot receive, possess, transport, or own a firearm. And if you do, you will be guilty of a felony which may carry a sentence of 15 years.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by pleading guilty to these charges?
Yes.
Okay. Mr. Oliver, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Yeah.
As to indictment 25SC001734, how do you plead to count 1, theft by receiving stolen property, count 2, hit and run, count 3, fleeing or attempting to elude a police officer? And for that charge, Your Honor, I failed to mention earlier that it would be reduced to a misdemeanor, fleeing and attempting to elude a police officer.
Okay,
It'd be the same code section, but just a misdemeanor.
right.
Count 4, reckless driving. Count 5, operating without lights required by law. Count 6, failure to obey a stop sign. Count 7, too fast for conditions. Count 8, failure to obey signs or control devices. And count 9, driving without a valid license. How do you plead to those charges, guilty or not guilty?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you also understand that this discretionary appeal procedure, which is outlined in OCGA 5635, must be completed within 30 days of today?
What is that?
Do I need this one? But
What is,
OCGA?
that's just the label for a statute. There's a statute, a law that the legislature passed that describes how long you have to file an appeal if you're going to appeal. And so Ms. Smith didn't need to give you the name and number of the statute, but she can. And she's just saying, based on this law, pardon me?
I was just wondering what.
Okay, got it. It's a great question. It stands for Official Code of Georgia Annotated, OCGA. That's the way we let people know, oh, that's a statute, a law that was passed. Like there's a law, you were pleading guilty to theft by receiving stolen property. That's OCGA 1687. That just means that's the law in the books that says it is illegal to possess property that you think is stolen. You didn't necessarily steal it, but someone gives you a car and there's a screwdriver in the ignition. Buy a hot car. And so if you're driving it, in theory, that's theft by receiving stolen property. But that number in the OCGA is just where we look up the law so that we all know what we're talking about.
All right.
Does that make it clearer?
Yeah, I got an understanding of.
Okay.
okay, I can ask that question again. Mr.
Maybe
Oliver?
without the OCGA part.
Yes, gotcha. Mr. Oliver, do you understand that the discretionary appeal procedure must be completed within 30 days of today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on October 8th, 2023, who's this officer? Trooper C. Ritchie, last name is R-I-C-H-E, was patrolling south on I-75-85 near Fulton Street. He observed a dark sedan traveling south on I-75-85 near Fulton Street also without his headlights or rear lights on. The trooper then got behind the vehicle and activated his emergency equipment to stop and conduct a traffic stop on the person in the car. The car stopped after the trooper got out of his car to approach the car that he stopped. That Kia, which was that dark color sedan, started to speed away from the trooper. The driver quickly accelerated and initiated a pursuit. The driver made a right on Fulton Street and continued down this street at a high rate of speed. The driver ran through multiple red lights and stop signs with no regard for public safety. The driver made a right on Dawson Street and continued down the street and made a right on Windsor Street. Eventually, the driver made a right on Connell Street, that's Connally, and a left on Georgia Avenue Street, where he struck another driver in a vehicle on Glenwood Avenue. The driver and passenger of the car then exited the vehicle on foot. Trooper then pursued the driver and placed him into custody, eventually catching up with him. The driver was identified as Mr. Elijah Oliver. The fleeing vehicle that Mr. Oliver was in was a Kia Forte. It was reported stolen and confirmed by Trooper C through the communication center. Mr. Oliver also confirmed that he was aware that the vehicle was stolen. The victim at that time of the car that was hit by Mr. Oliver was transported to Grady Hospital. Mr. Oliver was also transported to Grady Hospital. And once he was cleared by the hospital, he was transported to the Fulton County Jail and placed in custody. And those are the facts of the case, Your Honor, regarding the negotiated plea between the state and defense. We've agreed for sentencing for count 1 to be 5 years probation, for count 2 to be 12 months probation, for count 3 to be 12 months for the defendant to serve 30 days with the balance probated. For count 5, that'll be 12 months probation, 6, 12 months probation, 7, 8, and 9, also 12 months probation. And this is for all of the counts to run concurrent. As far as the special conditions of probation, we're recommending for the defendant to complete an anti-theft course, a defensive driving course, 40 community service hours, for him to not drive without a valid license. I was informed that he has a job, so a condition to stay gainfully employed, and also to stay away from the victims in this case, Your Honor.
So a little bit about the victims. You mentioned that as Mr. Oliver was trying to get away from this trooper, driving dangerously, he hits another car. It's not that he hit a pedestrian, he hit a car?
He hit a car.
Okay. And how many people inside that car were injured?
One.
One.
2 people, 1 person was injured.
Okay. And how severely?
That we don't know, Your Honor. We reached out to the victim multiple times. We haven't been able to assess the severity of their injuries.
Okay. And it's not in the police report that the person was unconscious or their leg was across the street. It's just that that person had to go to Grady.
Yes, Your Honor.
Okay. All right. So that's an unknown for the state. What the victims think about this outcome and frankly, how they're doing since this accident.
Yes.
Okay. And I think you said this, part of the police narrative was that Mr. Oliver acknowledged that it was a stolen car.
Yes, Your Honor.
Okay. Thank you.
That'll be all from the state.
We don't have anyone from pretrial on. What can you tell me about Mr. Oliver's criminal history?
He has no criminal history, Your Honor. This would be his first arrest, according to his GCIC.
First arrest? Huh. Okay. All right. Thank you.
No problem.
And Miss Simpson's on her way, so we'll talk with, she's here. She made it in. She slid in quietly. Normally she's in the jury box. I just didn't see you in the jury box. Okay. You're never disruptive. Hey, Colonel. Need to talk with her later. Let me add that to my list. Hey, I need to chat with you later today. What's the best? Just send you a text? Okay, thank you. It's not bad. It's about Gordon as usual. Ms. Rios, tell me about your client, this case. It sounds kind of scary what happened.
Yes, Your Honor. Mr. Oliver he's 20 years old. He lives with his mother. He did graduate high school. He is working for Olive Garden and plans to work at FedEx. He wants to take this case under first offender, so that does not hinder him being able to work at FedEx in the future. I'm gonna let him explain a little bit. I don't know exactly the details of the.
High-speed chase through downtown Atlanta?
Yes, I don't, besides what you've already heard, I don't have anything addition to talk about that case since I'm filling in today, but I think this was a resolution that makes the most sense between the both parties. And since this is his first arrest, doesn't seem like this is a situation where he constantly gets in trouble. This seems to just have been a bad decision one day, but I don't think this will be a continuation based on his history and the fact that he has a job, he finished school, and he seems to be doing well aside from this hiccup.
Pretty big hiccup, but I hear you. Okay, thank you. Is Mr. Oliver planning on going into custody right now, or was he talked 30 days is 30 days?
Oh, I thought he already did 30.
Nah.
3 days.
No, he's done 3.
Was that a part of the agreement?
Yeah, but she told me like, the days I served was gonna be, taken off.
Oh yeah, you get credit for those days, 100%. But it's 3, so that means there's still 27 days. And so my question was, and maybe I should be asking you, I always start with a lawyer, and you two may want to talk. The simplest way is you go into custody now. That's you showed up, you know what's going to happen. You've let your employer know and your family know. Sometimes people say, hey, could I have a week? Because I have a kid, or I have 3 more days at work, or I need to put my stuff into storage. You're not going away for all that long. I wouldn't want to do 27. It's still a while. But sometimes it's, hey, I'm going away for 2 years. And so I need to get some affairs in order. And I just wasn't sure what the plan was. Like I said, the simplest is you're going to go with Deputy Gordon now. You get credit for those 3, and you knock out the remaining 27, and it's behind you. But I don't know if you two want to talk about that, or if you've already.
I'm ready now.
You're good to go.
But
Okay.
I wanted to mention, I'm not employed.
Okay, well, I'm gonna ask you some questions. I had that question for Ms. Rios about, is Mr. Oliver going into custody now? But you've answered it. Answer is yes. I've got a few questions for you, and then you can add whatever you want. Olive Garden, you don't work at Olive Garden?
Nah,
Did you ever, or did she just make that up?
I did
Okay,
for like a year,
okay, when did you stop working at Olive Garden?
October
Okay, what happened?
this year.
Why did you stop working at the Olive Garden?
Well, really, I had got a new job, and then I just quit.
You quit the new job, or you quit Olive Garden?
Old job, and then the other job didn't work out. So then
Ooh, that's bad luck. What was the new job?
it was like a sales representative position in Dunwoody, I believe.
But it never even started?
Nah, but I went to the interview and everything.
Huh. And so you quit Olive Garden before you knew for sure you had the other job?
Yeah,
Did you try going back to Olive Garden saying, hey, I feel bad, let me wash those dishes or serve those breadsticks?
nah.
No. So you haven't been working since October. How's your mom feeling about that?
I'm pretty sure not good.
Okay. You want to work at FedEx?
Yeah,
What?
I had just got an interview up there. I was supposed to go to orientation,
Okay, what kind of work? In the warehouse or driving a truck?
warehouse.
Yeah, probably not with these charges, driving a truck right away. Okay. Tell me about this. Ms. Rio said you'd tell me about this. What was going on? It was just real dangerous, and I don't know, you stopped and then you sped away again. Maybe it wasn't your car. What was going on in October of 23?
It was my birthday night. It was the night before my birthday, and I just got into it in the car.
You got into, whose car was it?
I don't know. I just seen it.
And how did you make it go?
No, it was already like handled.
The car was running.
Yeah.
Was it at a gas station?
Nah.
It was just, you walked down the street?
Neighborhood, and we was just riding by.
Who's we?
Mm,
No, I don't need you to name names, but you said you were riding by, like you were in a car with some friends,
yeah.
and then there's this car that's sitting there running?
Mm,
Yes?
yes.
Okay, and did you have to pull the driver out?
Mm-mm.
No?
No.
Okay. Were you the only one in the Kia?
Yes.
Okay. What were you planning on doing with it?
It was just a simple joyriding for real.
A joyride, okay, with no headlights on.
Yeah, I didn't know, like, it was my first time really driving for real.
Did you not have a license? I guess you didn't have a license. Had you ever driven a car before?
Mm-mm.
That was the first time you ever drove a car? Huh. Well, that's quite a start. What happened in the end? You had to go to Grady?
They just checked up on me for real.
Did the airbags deploy?
I'm not sure.
Well, you'd know. Did this giant balloon come out of the steering wheel and shove you back in your seat?
It was so long ago, I couldn't tell you. I don't know.
Okay.
I think they did.
Do you know anything about the people you hit? Like what their injuries were?
Nah, the lady was fine when she got in the ambulance with me. But
Well, you rode to the hospital with the lady you hit.
yeah.
Was she like hitting you with an IV or something?
Nah,
Okay. Did you say sorry to her?
yeah, I did.
And I guess, Ms. Smith, we don't know anything about restitution to, you know, the owner of the Kia. But same situation, you guys haven't been able to contact that person?
Same situation, yeah.
Okay. So why do you think this won't happen again?
I'm gonna get my own car.
Right, but what happens if you're driving your own car and then a trooper tries to pull you over?
Just pull up,
You just pull over, okay.
get the right credentials and stuff.
Get the right credentials. What would those be called?
A driver's license.
Driver's license, yep, okay. Do you have a driver's license now?
Nah, it's suspended.
So you did have one?
Yeah, I got it after I got out
Oh, well then why is it suspended?
because the bench warrant.
Oh, yeah, why did you get a bench warrant?
I had moved from the address.
Okay, because you didn't end up going to, we just lifted the bench warrant, but it's because you all have moved?
Yeah.
Okay, all right. Tell me what you know about first offender.
I'm not really.
Okay, so first offender is something you qualify for because you've not been in trouble before as an adult. If I sentence you as a first offender, it's not a conviction. So if you're trying to go to work at FedEx or go to school or something, when you're filling out the employment application, one of the first questions is, are you a convicted felon? The answer is no, you're a first offender. You don't have to check that box. Because if you check that box, a lot of times they just throw that application away. Why would I hire this felon when I got this guy who's not one? You're not a convicted felon. You're on probation for a while, but there's no conviction. And if you successfully complete probation, when we're done, you can get it all sealed up. It can be pulled off your record, all good stuff. But if you're going to be a knucklehead in the next few years and do something like this because, I don't know why I did it, it was fun, then first offender can be a bad thing. If you pick up new charges, not only do you have that new case, but we would get back together. And if the state could show me with enough proof that you have the new charges, then because you've already pled guilty, I could resentence you. And it could be for a fair amount of time with all these misdemeanors added on top of the theft by receiving, which is probably 1 to 10, if not more. So you could end up going to prison for a while, not on the new charges. I don't know what would happen with those, but because of this, because you're telling me, Judge, don't worry, I'm not going to get in trouble again. I'm going to work. I'm going to be smart about things. And then you're not. So if you're back here as a first offender, but in trouble again, the first offender sentence can pretty quickly turn into a prison sentence. You can be resentenced. If you don't get sentenced as a first offender, you just get probation, I could revoke your probation, but you know the universe. You have 5 years probation. It can't ever be more than that. And so the most I could revoke is 5. With this first offender, because I get to resentence you, we start from 0. Like I said, I'm going to tell you, if a year from now, we're having a conversation because you stole another car and you crashed it and you hurt someone, I will send you to prison for a long time. And I've got a lot of time to work with here, 10, 15 years, if you're sentenced as a first offender. If you don't go as first offender, like I said, your ceiling is just these 5 years you're pleading to. I just said a whole lot. Did you feel like you followed it?
Yeah.
Do you feel like you understand the benefit of first offender, no criminal history, and the risk of first offender? If you screw up again while you're under this sentence, it can come down on you pretty hard.
Yeah.
You understand that?
Yes, I do.
Understanding it, do you want to be sentenced as a first offender, or do you think, man, I don't think I'm ready to stay out of trouble in that
So
way?
if I wasn't sentenced as a first offender, I would be convicted, right?
Yep, you'd be a convicted felon. And so FedEx would run your history and it would say he's a convicted felon, theft by receiving.
Okay, I'll be first offender then.
You want to try that out?
Yeah.
Even though there are some risks attached to it? Yes?
Yes.
Okay. All right. Do you have any other questions about things we've been talking about?
No.
Anything more you want me to know about October 8th, 2023 and your joyride?
No.
No? Okay. Well, Mr. Oliver, I find there's a factual basis for your plea, that your plea is knowing and voluntary. That means the knowing part means you've understood everything. And when you didn't, you asked, like, what's this OCGA thing? Voluntary means no one's forcing you to enter the plea, but you've decided this is the right way to go forward. Do you agree with that?
Yes.
Ms. Rios, can someone in my office sign the indictment for you?
Yes.
Ms. Smith?
Yes, Judge.
And Mr. Oliver, can we electronically sign your name to the indictment?
Yes.
All right. I will sentence you as a first offender. Your sentence as to count 1 is 5 years to serve 30 days with the 1 month. 5 years to serve 1 month with the balance probated. Counts 2 is 1 month to serve. All the remaining counts are 1 month to serve because there was one that was a felony. The state has reduced to a misdemeanor. So count 1 is 5 years to serve 1 month, balance probated. All the remaining counts, which are misdemeanors, are 1 month to serve. They're all running at the same time concurrently. So your total sentence is 5 years, serve 1 month. You'll get credit for the time you did serve. You will, when you are released, be on probation. You're going to talk with Ms. Simpson from probation in just a minute about where you're going to be living and where you report. While on probation, you'll need to complete a defensive driving course. That'll help you get your driver's license back. You'll need to complete an anti-theft course. And within the first 6 months of your probation, you'll need to complete 60 hours of community service. It's a little bit more than what the prosecutor said, but I think that better fits what we're dealing with here. Any questions about any of that?
No.
Ms. Rios?
I would ask if you would be inclined to set a behavior incentive date.
I think as first offender, I'm going to leave it as we have it. Ms. Smith, anything else?
I know that the state was not able to get in contact with the victims. However, will it be a condition of probation for the defendant not to have any contact with the victim?
Yeah, I don't mind that, but I don't think you don't know the people that you hit. So I've thought about more saying no contact with this complete stranger, because sometimes that's sort of what it is. And unless they've reached out to you saying we're scared of this guy, I just don't think there's a reason why their paths would ever cross anyway. Okay. Yep. Ms. Simpson, do you want to talk with Mr. Oliver right now, or do you want to talk with him, talk to him back there? Ms. Simpson's just going to get a little bit of info about where you live, maybe your mom's phone number or something like that. So she's got point of contact and give you probation reporting instructions. Okay?
All right.
All right.
I think his mom wanted to say something too, Judge.
Okay, Mom, you're here? Hey, good morning.
Morning. I appreciate everything so far. I just wanted to add that, the incident occurred when he likely was a teenager, so you have the impulsiveness of a teenager, then on top of that, he has a medical diagnosis of ADHD.
Okay.
And so I think both of those combined together did play a role in the impulsiveness, and then it was his birthday.
Right. And he just like, hey, this could be fun. I'm not going to worry about the consequences or think through the consequences. Well, hopefully a few more years that he's aged to help with that. Mr. Oliver, do you take any medication for the ADHD?
No.
Have you ever been prescribed medication for that?
No.
No? So
Yeah, counseling though.
counseling. So I'm going to add one more condition of probation, and that's that when you are out, you are going to submit to a mental health evaluation, because then you're going to meet with a doctor. And if that doctor recommends any treatment, whether that's medication or counseling, that'll be part of your probation as well. Okay?
All right.
All right. Thank you, Mom, for sharing that. That's helpful. Thanks, Ms. Rios, for pitching in. Your eyes got pretty big when 30 days.
Well, because I didn't remember her saying that, so I was just trying to make sure I didn't. Something.
Regarding my case, the Mendez Carranza case, do I need to submit any paperwork?
Only if you want to. You made a motion on the record that, well, to me in court, as well, good enough. I don't think we were taking it down because we didn't need to, that you want to dismiss the charges. And so Ms. Nelson is good at putting a stamp on there and we sign it. Sometimes prosecutors want to, for the record, as in what's in the docket. So 10 years later, if someone comes in and says, oh my gosh, why did charges of this nature go away? 100% your call. What you said is more than enough for Ms. Nelson today to take care of the null pros piece. And if that's sufficient for you, you don't need to do anything else.
Okay, I will inquire if I need to do that.
Okay.
Supervisors, but beyond that, I believe that concludes my business. Can I be excused?
Yes, ma'am.
Thank you so much, George.
Ms. Smith, do you need to speak with Mr. Richardson at all, or are you good to go?
Yes, I can speak.
Do you guys need to talk more, or are we ready to start?
I guess I think she directed me to Mr. Miller.
Yes, but I asked Ms. Smith and she says, I don't see Mr. Miller. And she said, Ms. Smith said she's handling it for today. Is it not resolved yet?
It is not. I just found out when I got the message from teacher that he should be rejected from the conversion program.
Right. So here's what I had heard. I'm sorry, I thought that then there had been communications with Mr. Miller. You didn't speak with Mr. Miller?
I'm not. What I did was, Judge, I sent her supplemental information about Mrs. Dawson, and she was going to forward it to powers that be for review. It was yesterday.
So why don't you two talk a little bit? It may be that the state is where you were hoping they would be. I don't know. I don't want to put Ms. Smith on the spot, but you guys should talk. And if Mr. Miller needs to get in the mix, that's great. That would be a Ms. Smith call. But I just need to let jury services know, are we bring jurors in or are we working the case out? So why don't you guys talk? Don't talk?
I can speak to y'all a little bit, but I'll speak with.
Yeah.
Well, he wants to talk to the judge directly. I told him he would talk to his attorney who handled the case, which was Renee. Yeah, but his license was suspended or something because the plea took. But I don't think the judge can't.
No.
Okay, we
I don't know
what
his real
he
name.
is. We don't know whose real name is.
Like,
Are you sick?
no. Just helps me with. I'm not going to get dry. No, no. So it just always does that. What's Mr. Way? Yeah. Okay.
Right. Hey, Mr. Way, how you doing?
I don't know.
I'm all right. So Ms. Rockwell had reached out, not about your driver's license, but about, I think it was shifting the days of the week for the weekends. I hadn't gotten around to that yet. Ms. Rockwell generates lots of homework for me. but I wasn't opposed to shifting the weekends around. Deputy Gordon told me there's an added complication that now your license got suspended?
My commercial driver license.
Your CDL,
Yeah, it's been disqualified and it said.
which you need for work?
Yes, it said due to commercial disqualification and I don't understand. And it said that this disposition date was October 16th, 2025, which was when I was in court.
Okay.
I've been trying to get some kind of answer because this is my livelihood.
No, I understand. You had the supervisors here saying how it was important. Have you talked with Ms. Rockwell about that yet?
Picture of this, I'm talking about coming here to talk to you. I haven't got a response back yet.
Okay, well, let me tell you the way you need to sequence it. I don't know why that happened. I don't know if it is within my authority to fix it, but Ms. Rockwell needs to do some homework to figure out why did that happen and what is the way it can be fixed. Because she may say, oh, you gotta, I'm making this up, you gotta pay $100 to driver services, or we need to do this application, or it may be the judge needs to do X. I did not intend for your sentence. The whole point of structuring your sentence was so you could continue to work for the city. And here we are, and you're not able to do the important work you do for the city. So I would be inclined to help out if there is a way I can help out. But it's Ms. Rockwell's job to figure out what buttons need to be pressed to fix that. And she may have bad news for you. She may say, by operation of law, that's what happens. But she's super smart and she may say, you know what, maybe I'll get with a prosecutor and we could have you plead this way, redo your plea to this and that. As long as it's not changing, you're not coming back here saying, oh, I want fewer weekends. All you're saying is, could I not lose my CDL? And I am supportive of you not losing your CDL. I know it's a bit of a project, but you got to track Ms. Rockwell down. And she may say, I don't do that for free, but that's where you need to start.
It was just conducive for me to talk to you directly.
Yep. No, I get it, but chat with her so she can figure out what steps need to be taken to fix that. And let her know you spoke with me and I said, I am supportive of fixing it. All right? Good luck.
She's in Africa. She'll be back in 2 weeks.
So there's part of your problem. Well, your plan B is she is not the only lawyer in Atlanta. And so if you have friends who are like, hey, I recommend this person, you're welcome to reach out to a lawyer and say, just show them that. Like, how do we fix something like that? And again, they might not do it for free, but they could get you moving in the right direction. Okay? Good luck. Great. Ms. Dawson, if you and Mr. Richardson will come up to the podium, please. Okay. It's a misdemeanor plea.
Should I catch him?
No. This is the probation person here. And she's felony only. So she perked up, like, this means I can leave now. Yeah. No, I won't, other than, I got all your emails and we exchanged emails. I'll probably still be reaching out to Beggs.
Please do, because he just left our office this morning.
Oh, as in Memorial or down?
Downstairs.
Okay, did he add anything to the equation?
They were doing measurements for.
As in do you know?
They're not saying, we were told everything the same.
Well, that's so generous. Maybe in exchange for the laptops.
Also, because we were told, we weren't mentioned about laptops. We were told it was going to add it to our laptop, and our laptops are actually not compatible.
Okay. And that's what he said, or XO said that?
That's what Chief Carlton was.
Okay, Chief Carlton. Has Chief Lane said anything about it, or Chief Carlton is the main conduit?
She is the go-to.
Okay.
Messenger in between.
Yeah. All right.
But if you can, please, because your word holds weight.
I don't know about that, but I will, he's on my list of people now that we're not going to trial, that I get to fill my week instead. Do you have a phone number for him?
I do not, but I can go sign.
Pardon me?
I can give him somebody.
Excellent. If you could email me his phone number. Thank you.
I was actually in the middle of sending an email before I ran up here. I need to send an email in regards to one of our.
Okay. All right. Thank you. You bet. Bye, Ms. Rios.
The first possible,
What was that?
the first, December first.
Oh. Okay. In case one of your cases goes out.
Yeah, well, your lister should show up.
Well, I'll tell you what, if we pick a jury next Tuesday in Poole, I'll let everyone know we picked a jury in Poole and that's what we're doing.
Yeah, we can't have that same. So.
Why not? You wouldn't have picked it. You won't like it.
Yeah, sure. Okay, have a good holiday.
You too.
Later.
All right. Our other plea this morning, Ms. Dawson, let's get on the record. 25 SC 002 756, State versus Dawson. Ms. Dawson is in court with her lawyer, Mr. Richardson. We have Ms. Smith for the state, and Ms. Dawson, it sounds like after much back and forth, your lawyer has now negotiated something that you're comfortable going forward with. Is that correct?
Yes, sir.
Okay. Comfortable may be the wrong word, but that you are willing to go forward with.
Yes, sir.
All right. Ms. Smith is going to put you under oath, ask you questions about your rights and your case. You need to answer those truthfully, and you need to let me or your lawyer know if at any point you have questions or you're confused by anything. Will you do that?
Yes, sir.
All right, Ms. Smith?
Thank you, Judge. Ms. Dawson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
My marriage name or the name that's on this case?
Like what, if you're introducing yourself to someone right now legally, what would you say your name is?
Denitra Dawson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, no.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
I'm 33 and I graduated from high school, but I'm taking college courses too.
Where'd you go to high school?
Life Christian Academy.
Where's that?
Then it was in College Park, but he have since located to Forest Park, I think.
He as in the person who runs it?
The owner, yes, sir.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with his services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Ms. Dawson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We're not aware of it.
Do you understand that you are entering a guilty plea to the following offense? Count 1, aggravated assault that has been reduced to pointing or aiming a gun or pistol at another. And for count 2, which would be Norcross.
Yes.
Do you understand that this is a negotiated plea of guilty, which means you, through your attorney in the state, has reached an agreement on how the case should be resolved, and we will present that agreement to the court for consideration?
Yes.
Do you understand that the state will recommend to the court a sentence of 12 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge, well, which is 12 months? You already have that disregard. Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes.
Do you also understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
Yes.
Do you also understand that you have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any other special conditions of probation without being subject to revocation for the balance of the sentence?
I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
I do.
Are you currently on probation?
First offender.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering a guilty plea here today?
Well, Judge, in this case, that's not the case because this case existed prior to her taking probation, so it wouldn't trigger a revocation in this instance.
When did you get on first offender probation?
So I had caught this case, and then so I said like 2 weeks, and Mr. Richardson had got the judge to go on and handle the case.
Well, so it sounds like actually you'll know Mr. Richardson.
It was
There's a felony case out there.
Right, that she's about 3 months from completing.
Okay.
When she picked up this case, she was in custody. She could not get bond. So what we did, we went before Judge Krause. We took a plea on the case that existed while this case was still in its kind of preliminary stages. Once she took a plea on Judge Krause's case.
Got it.
then
This conduct of pointing the gun at Ms. Thomas occurred before Ms. Dawson was on probation.
That's correct.
Got it. So this plea will not be a basis to revoke your probation with Judge Krause, which is almost over anyway.
Okay.
That's correct.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
I do.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands these rights they'll be waiving by pleading guilty to these charges?
Yes.
Ms. Dawson, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
But she'd asked the court to consider allowing her to enter her guilty plea under the auspices of Alfred versus North Carolina.
All right. So Ms. Dawson, that is lawyer code for you don't necessarily agree with everything. She hasn't said it yet, but in a little bit, Ms. Smith is going to give me what she'll describe as the factual basis for the plea. And my guess is it's going to be there was some situation and Ms. Thomas says you pointed a gun at her. And we'll hear all the details from Ms. Smith. You can still enter a plea even though you disagree with that and that you think that's not how it happened. There's more to it, or there's some part of it I don't agree with, but you can still say it's in my best interest, meaning your best interest, to enter a plea, even though you don't think that's exactly how it went down. Does that make sense?
Yes, sir.
That's what an offered plea is. It's, Judge, no, I'm not saying I did everything she said. Maybe you had a gun, but you never pointed it. Or both people had guns, but no one's talking about the other gun. I'm making all this up. And Mr. Richardson will share with me what he thinks he ought to about maybe more of the information in the case. But instead of saying, great, there's a disagreement, we go to trial, a defendant can say, no, I don't agree that that's exactly what happened, but I still want to work the case out. Does that describe you?
Yes, sir.
Okay. You need to understand that it's still a conviction. It's a misdemeanor, it's not a felony, but the fact that it's an offered plea doesn't mean that it doesn't show up. If someone runs your criminal history, it'll show pointing a pistol at another. That's what you're pleading to. It'll say offered, and if you were ever in court again, you or your lawyer would be able to say, yeah, she did resolve it, but it was an offered plea. But I want to make sure you understand all that.
Yes, sir.
Okay. Ms. Smith?
As to indictment 25 SC 002756, how do you plead to count one aggravated assault, which has been reduced to pointing or aiming a gun or pistol at another?
Guilty on the offer.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you also understand that that discretionary appeal procedure must be completed within 30 days of today?
Yes.
Do you understand that you have only 12 months for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on June 18th, 2023, Officer Wright responded to 405 Fairborn Road, Southwest Atlanta, Georgia, 30331, apartment 61, in reference to a dispute with a weapon. Upon arrival, Officer Wright contacted the caller, Ms. Starlethia Thomas, and several witnesses who stated that Ms. Dawson got into a verbal altercation with her neighbor, who was Ms. Wilcox, who was also the mother of her children's father. So it's her mother-in-law because she's married to him, correct?
Ms. Wilcox.
Yes, Ms. Wilcox is the defendant's mother-in-law.
Right, and the argument, what people are telling the police is, hey, Ms. Dawson and Ms. Wilcox got into a verbal dispute.
Yes.
Okay.
And then what happened from there is that the victim, in this case, Ms. Thomas, tried to de-escalate that verbal altercation between the defendant and Ms. Wilcox. Once the defendant then once the victim tried to de-escalate the situation, the defendant, it is said by Ms. Thomas and witnesses that she pointed a gun to Ms. Thomas in reference to the argument that was then going on between her and Ms. Thomas. At that point, Ms.
And Ms. Thomas is connected to this group because she's a relative, or she just is also a neighbor?
So Ms. Thomas also lives in the apartment complex, but she also shares the same mother-in-law as the defendant. So through marriage, they're family. Ms. Wilcox is the mother.
Yep.
She has two sons. One is married to the defendant, one is married to the victim.
Interesting. Okay. All right.
So after that, when the officers come back and based on eyewitness testimony and the testimony from the other witnesses at the scene, Ms. Dawson was placed under arrest and taken to the jail. And those are the facts of the case, Your Honor, regarding the negotiated plea between the state and the defense for count one that has been reduced to that pointing or aiming a gun or pistol at another. We've come to an agreement of 12 months probation for that sentence. And regarding and for count two, of course, that would be no pros. For the special conditions of probation, we're asking for the defendant to not have any contact with the victim, who is Ms. Starlethia Thomas, to stay away from the incident location, not just that apartment number, but the apartment complex altogether. I think the name of it is Wildwood. That's what I saw when I looked up. Great, okay.
Wildwood Apartments. And I know you said Fairburn Road. Is that in Atlanta or is it in one of the smaller municipalities?
In Atlanta.
Okay.
Atlanta, Georgia, 30331.
Okay.
For the defendant to forfeit the firearm used in this offense, also for her to complete an anger management course and to have no further violations of the law. And that's all from the state, Your Honor.
Okay. And has the state had any contact with Ms. Thomas or Ms. Wilcox to get their perspective on what should happen, or to alert them that, one, Ms. Dawson's not going to jail based on the state's recommendation, and that it's a misdemeanor, not a felony?
Yes, Your Honor, I did speak with Ms. Thomas in this case. I told her about the first offer, and she said she was okay with that. I then called her to let her know that the state is thinking about reducing the charge to misdemeanor, which she said she was fine with. She did not want the defendant to be incarcerated or to get into a lot of trouble because she has kids that she needs to take care of. She's just mainly concerned with the defendant not having any contact with her.
Okay.
She also stated that because they're through marriage and in the same family, that if there's an event that the defendant will be at, she will just on her own not attend that family gathering. But she does want it to be that there's no contact between her and the defendant.
But Ms. Thomas said, look, I'm coming up. Thanksgiving is coming up. If there's going to be a Wilcox Thanksgiving, Ms. Thomas just won't go. It's not that Ms. Dawson doesn't need to go. Ms. Thomas said, I'll just make it easier and I'll go to Popeyes.
Yeah, I asked her, I said, is she sure, are you sure that if you all are at the same or invited to the same place, that you'll be able to remove yourself? And she said, yes, she just doesn't want to be around the defendant.
Okay.
And she doesn't want there to be any contact between the two.
Okay.
But she was okay with the offer and the reduction.
All right. Thank you for that update.
Problem.
And it sounds like Ms. Dawson is on first offender probation right now. Were you aware of any other criminal history?
No, Your Honor.
Okay. Thanks for filling in for pretrial today. Mr. Richardson.
Yes, Judge. Court knows Ms. Dawson's 33 years old. She's employed with MARTA. Right now, she works in the maintenance and custodial services with the objective of trying to become their trainer.
Right. You mentioned this when we were like, why are we going around and around on this one? Because she's got these job prospects within internal promotion.
That's correct, Judge. She is the mother of 6. She has 3 boys, 3 girls. The oldest is 16. The youngest is 10? 6. 6. She has 5 children by Mr. Jeremy Brooks, who is the son of
Ms. Wilcox.
Ms. Wilcox, that's correct. She has another daughter who is by another gentleman who, before she ever met Mr. Brooks. They live together, they raise their children together. So effectively, Mrs. Wilcox has 5 grandchildren from their marriage. Judge, she explains to me, and I did explain this to the state, that on a particular day, the date listed in the bill of indictment, sound like a DA, she went to the location because her husband had left some of her lingerie, some gifts she had bought from her at the mom's house. She thought it was pretty irresponsible for doing that.
Awkward.
Right, a little awkward.
Like, what's this?
Right, right. So she went.
Jeremy.
She initially sent her girls, 2 of her daughters, her 12 and 13-year-old, to get it. The grandmother said, no, your mama come in and get it. They got into exchange of words. It was
Wilcox and Dawson.
Got into exchange of words.
Wilcox said, you got to come get this.
Right.
What is this?
Right,
Yeah.
right. And it was, I think, a misunderstanding. She was arguing with her about Jeremy, the son. Jeremy has a brother, Tim, who is connected to the victim, Miss Thomas.
Okay.
I think she has a couple of children by him. Miss Thomas, I think, mistakenly believed that she was arguing with Miss Wilcox and being disrespectful to her. She was being a little curt, but more about Jeremy and his disrespect and him having her come over, blah, blah, blah. Miss Thomas injected herself in the conversation. She told Miss Thomas, this is an A and B conversation, see your way out of it. And it escalated from there. Another neighbor who was not blood related joined in the reindeer games. More conversations ensued, so much so that the girls, her daughters, went to the car and got a bat because they thought they were defending their mother. They were going to.
How old were they at the time they got the bat?
Think like 10 and 11.
That's some mother love.
Right. So Mrs. Dawson had a firearm that she legally owned. She had it down in her leg. I asked each of her daughters separately. They both said, my mom had a gun, but she didn't put it. We had our bat. Okay. There was another young man who came from the apartment of Miss Wilcox. He had a long gun. Of course, when the talk of police coming, he disappeared to the back of the apartment and went on his way.
Yeah.
Never to be seen again. She left the location. She said her personal situation was occurring. She wasn't running from the police, so she actually returned back to the location. And when she got there, the officers were there. They inquired. She left her daughters back at home. The officer inquired. She said, what about my witnesses? On the videotape or the body cam that I watched, the officer said, well, they're kids, so they can't testify. Well, I know that's wrong. You know that's wrong. But that's what he said. So he only got one side of the story and never her side. But that's what we had. She was arrested. That's why we asked the court to enter the plea under Alfred versus North Carolina. She understands a jury of 12 could do anything. Then the court is faced with, she's a first offender already. You couldn't bless her with a first offender to protect her job or her family. Though her and Mr. Brooks have been together for many years, they only got married like 2 years ago. So she has been the provider, protector of her sons and daughters effectively all of their lives. She still sees herself that way. That's why when you ask her, how does she see herself? She says, still Dawson, because Jeremy's still learning how to be a father and a husband. And so she has a lot to lose, a lot to gain. She's very proud. She has, I think, 2 kids at KIPP Academy. They're all very good students, they're very disciplined. So that is why we entered this plea, and we thank the state for the consideration. It still keeps her life kind of in place. allows her, she's agreed to surrender the gun without contesting it. And she is actually on her own volition done an anger management class. I think I told her, do it in abundance of caution, and that way you have that. If it gets the satisfaction of probation, then it does. If it doesn't, then take anger management, be done with this and put this behind you. So that's why we asked for Alfred. So,
okay. Ms. Dawson, what were the or Mr. Richardson, the case with Judge Krause, what were the charges there?
that was an unusual case, Judge. I actually handled that case as well. Ms. Dawson, again, with her children, had been the victim of an aggravated assault. Person tried to actually shoot at her in her car. She knew who the person was because it was a girlfriend of hers, boyfriend.
Meaning Mr. Brooks?
No, not Mr. Brooks. A girlfriend of hers.
Yeah.
Boyfriend.
Oh, the person who shot was boyfriend.
Right.
Why?
Right. There was an exchange of words. And
okay. And his thought was, I'm going to shoot at your car.
Right.
With kids in it.
She took out, right. Well, she took out a warrant for him. He got away. He'd been avoiding the East Point Police Department for some period of time. She found out where he was. She called the police and told them, there's a person there who has a warrant for me. No one shows up. She called the police and said, someone's been held hostage. SWAT shows up, police show up, they get him. But of course, when they play it back, there's no hostage. Police are suited and booted. They said, you kind of escalated this thing to somebody really could have got hurt.
So she was prosecuted for that?
Prosecuted for a felony, false report of a crime, et cetera. So that is we did first offender on that thinking nothing like this could ever happen. But here we are.
Ms. Dawson, you've had an interesting few years. I hope that maybe converting life with Mr. Brooks to married life will help. Is he working?
Yes, sir.
What does he do?
He worked for DeKalb County.
Oh, you told me that before. What is it? It's sanitation?
Yes, sir.
Yeah, okay. You need to have less controversy in your life. You know, you can't have a gun while you are under either of these sentences. It sounds like your sentence with Judge Krause is going to end in just a few months, but no firearm in the household, no firearm on you, near you, while that sentence is going. And while you are under sentence here, so 12 months from now, over these next 12 months, no firearm.
Yes, sir.
Okay. Plus your kids have a baseball bat anyway. You don't need a firearm. Do you have any questions about what we've been discussing?
No, sir.
Okay. You understand you're going to need to stay away from Ms. Thomas. And while Ms. Thomas has said she might leave a family event if you walk in, she don't have to do that. And I mean this figuratively, not physically, if push comes to shove, and you better not be pushing her or shoving her, if you show up and, hey, we're all celebrating Christmas or whatever is being celebrated, and Ms. Thomas is there, unless she said, I'm going to be leaving now, you can't be there during these 12 months you're on probation.
Judge, I think there's a built-in cure for that, because part of the conditions was that she stayed not only away from that Mrs. Wilcox apartment, but she stayed away from that complex completely.
I understand, but if the Thanksgiving, pardon me?
If she's hosting at her home.
Right, if you're hosting, that's no problem, because you wouldn't invite Ms. Thomas, but maybe the entire family unit, other than you, is around the Wildwood Apartments. I was envisioning that in Hapeville, you guys have some family event. Great, I'm going to this, we're going to Red Lobster for this thing, and if Ms. Thomas is already there, you can't be at that event while you're under this sentence. You understand that?
I understand.
Okay. Obviously, if you're hosting, you don't invite Ms. Thomas. You can be around your family. That wasn't my point. I don't know why you'd want to be around Wilcox or Thomas, given how all this played out.
I don't.
But you're under a legal requirement to leave Ms. Thomas alone. And no contact doesn't just mean, oh, I see her in the room, so I better leave. It means no texting. It also means no posting something online, calling her out. If she is able to get to the prosecutor, look, all these posts from Dawson saying Thomas is a liar or Thomas this or that, you saying things about her that are meant to get to her eventually, that would be contact. And that would be a quick way to turn your probation into being away from your family, okay?
Yes, sir.
But it sounds like you get that.
That means your family too.
Yes.
She has a large family.
Okay,
No,
anyone, I should have just been clear, it means you would go to jail. If there is credible evidence that you were trying to get word to Ms. Thomas, whether it's I'm sorry, or once I'm off this sentence, baseball bat time, that won't end well. All right, Ms. Dawson, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Mr. Richardson, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith? And Ms. Dawson, can we sign your name to the misdemeanor plea to count 1?
Yes, sir.
We'll do that. Mr. Richardson, are you asking to withdraw from the case now that the plea has been entered, so I can enter an order that gets your name out of the docket?
Yes, Judge, please.
I will do that. It means so much with a 12-month probation, but a new thing we're going to try to do, especially with felony cases with retained or counsel who are lending a hand who's not a public defender, is get them out of the case so that if there happened to be a revocation 6 months later, the notices aren't going to, like, I don't represent this person anymore. Okay, I'll take care of that. Ms. Dawson, your sentence as to count 1, which has been reduced to pointing a pistol at another, is 12 months. That will be probation. Special conditions of your probation are: number 1, no contact with Starlethia Thomas. Number 2, stay away from the Wildwood Apartments in Atlanta on Fairburn Road. Number 3, you forfeit the gun that was seized. And then 4, complete an anger management course. And I encourage you, if you got some certificate or whatever it was from the course you took, show that to the folks at misdemeanor probation. I hope they'll say, done, you've taken care of it. I do not mean for you to take another one unless there's something about the course you took that maybe it wasn't registered or it was with this kind of person and not a professor or a certified anger management consultant or who knows what. But I hope that if you finished it and you've got proof of completion, that checks that box for you. Okay?
Yes, sir.
Judge, you didn't say it, but possess no firearms and not be in a dwelling with firearms, correct?
So you got to do that anyway, but I'll make it clear, no guns while you're under sentence.
Yes, sir.
Okay, not in the house, not in the car. If Mr. Brooks is a gun kind of guy, those need to be kept somewhere else as long as you're under sentence. Okay?
Yes, sir.
Are there guns in the household?
No, sir.
Okay, I guess that gun you had, but that was 2 years ago. You didn't replace it?
No, sir.
Okay, good. Don't do it till you're off sentence if that's what you choose to do. Ms. Smith, anything else in the case? All right, Mr. Richardson, anything else? Thanks for your help with the case. Ms. Dawson, the next step for you, either through Mr. Richardson or directly from misdemeanor probation, you're going to get an email saying you need to call or report. Most of the reporting will be virtual, meaning you can make a phone call or something. But it may be just to get it started that you have to go to their office. Their office is about a block from here. So if it's not hard to get to court, it's going to be easy to get to the probation office. But I don't know how that works, other than that you'll get the information either from Mr. Richardson or we'll push your contact information to probation and they'll call you. Don't ignore them because they need to sign you up. And if you ignore them, then they'll just reach out to me saying, we can't track this woman down. Here's a warrant. Okay?
Okay.
All right. Any questions?
No, sir.
All right. Well, good luck with all those kids. Are you done with kids or you're looking for a lucky number 7?
No, I'm done.
All right. I think 6 is a healthy number.
Yeah, I'm done.
All right. Does Mr. Brooks think everyone's done?
Oh, I don't care. I'm done.
Well, you can make it so he can't, but good luck with all that. All right.
Maybe his kids.
Yes, sir.
Take care of it. Thank you.
Ms. Smith, you had sent an email about coming by and now have almost 2.5 days of doing that. So I will reach out and you should feel free to come by. You can chat with Ms. Nelson and with me and all that.
Okay.
All right.
Sounds good.
Thanks.
Oh, I have a quick question about the motion we did to, was it a motion to suppress our
In what case?
squatter case? Need to get the name. Lacey and I did.
Oh, yeah. I didn't rule on that yet.
No.
Okay. I was looking for case law. You gave me 2 Supreme Court cases. I could have sworn I did. Did you not check because now I remember I included a quote from Rakes, which was one of the cases you cited.
Did you?
I denied it.
Okay, when you sent it, did you send it to like our emails or was that just on Odyssey?
I don't send anything. What I do is I write an order, I sign it, and I give it to Ms. Nelson.
Oh, she filed.
She e-files it, and so you need to be, and so it may have gone to Ms. Davis.
No, I think I probably did. I need to go back through the e-files. I get so many.
You do, you get a million billion, and so you're gonna need to come up with a screening mechanism, is like, I'm not interested in that. But if you've done a good argument, which you did in this case, then you may just wanna have a post-it note saying, hey, check the docket. Or better yet, just ask Ms. Nelson, hey, did the judge rule on that? But I ruled on it in your favor, in the state's favor, and you should read the order.
Okay.
I don't remember the gentleman's name, but I remember the case. Right, because this was actually it was a weird squat. Squatting I usually think of as like an abandoned house, but this was the Invitation Homes Company. Yep, done.
Okay,
Right,
thank you.
sure.
And I made cookies last night to give to everybody in the court and everybody.
Oh,
So
well,
I want some cookies ready.
yeah.
No, me too, actually, but nobody.
I saw you bring that in. I didn't want to call you out on it. But like, hey, what's going on?
I literally wanted to give them.
That means more for us.
But no, would you like cookies?
No, yeah, but serve them first. And then what you really need to do is bring it back there and if there's enough, and let Ms. Nelson and Ms. Hansberry get a little back. See, this is a reason to keep you in the courtroom. A body is like just brings woe and not cookies. We back in the day would have a holiday luncheon and people would each bring something. And did you and Dutcher overlap a little bit?
Maybe.
Pat Dutcher?
Maybe.
He had your role when I started. But it was an odd coincidence because he was like kind of running major case, but had one courtroom, and this was the one he picked. And so he would bring like the worst store-bought stuff. People would make stuff. The whole point was find a recipe you enjoy and make something. And Dutcher brought like Publix something.
Or make it look like we made it.
Yeah.
And I may have been wrong, so I apologize. I was under the impression you were not here yesterday, so I wanted to make sure I told you I asked Judge Parnasol just to sign interstate compact.
I was not here yesterday.
For Mr. Poole's case, because there's several witnesses who are in Tennessee.
In Tennessee.
I wanted to make sure I did that before the holidays. I just wanted, if you saw it on the document, I want to make sure I wasn't trying to go around you.
Nope, no. Something administrative, I mean, you can always ask Ms. Nelson, but if it is administrative like that, I'm not feeling circumvented.
Thank you.
You bet.
How would I be able to give them the cookies?
Oh, Deputy Gordon can get you back there.
Okay.
You want another one?
Okay, I'm gonna bring you the order.
No, get one.
We're back at 1, right?
You got 2 already.
We're done.
No.
Oh, what?
You didn't close it, did you?
No.
Okay, no, we have the 1 o'clock with the juvenile.
Chambliss.
Oh, now we can do that. Yes, that was you.
I wish we would have brought the other.
Marriott.
Yeah. But.
I could go get
Ms.
it.
Nelson?
I'm coming to
Some
see.
cookies.
Oh my gosh.
I think they're pretty good. Grab you 2 if you want, honestly.
Well, I have to give us hands here.
So grab 3, 2, and you will want her, and she won't.
Is it nonsense?
No. So this is Michelle.
Okay.
Thank you.
Man, this is like the first. Yeah. I'm gonna have to keep hers.
Breathe, girl. You got 3 cookies.
Ordered. Nice.
Stop calling her.
Okay, so you're gonna be back, right?
Yes, ma'am. We're back at 12:30.
I went to the,
Yeah, be the man.
I was in 2B yesterday. Ashley, like everything on the sheriff office, and then at the end, it was baseball. So some juveniles wasn't brought over. The border got their sense at 2 p.m. But the calendar and everything said 1. So they got us scrambling around and they were gonna get us too. He dogged her bad. He dogged her bad.
Hey, thanks for the cookies.
No problem.
This cord is bothering me.
Oh, the white one.
Yeah.
Yeah. I thought maybe we'd get one of those, like,
Cover.
yeah, that you can tack to the wall.
I'm gonna just bundle it for now. I don't know which camera view is giving me this view, but I'm like, oh, that's.
The witness stand,
Huh?
the witness camera, the witness stand.
The witness camera, you see the cable.
Yeah, he dogged her bad at open court. And then they found out it was their fault.
Did he own that?
He in the back, not in the courtroom, not in the court. We had 28 defendants, they did not indict one. It was a long day yesterday.
Meaning normally they'll call the calendar and the state will say, oh, we already indicted that guy, so he comes off. So you had to do all of them.
Well, we had a couple consents in there, but most of them was hearing.
Yep.
I didn't get out there till like 5.
All right. So, Mr. Rayleigh, she was charged with aggravated assault, but the state reduced that to the misdemeanor that you heard the plea on of pointing a pistol at another. That was just what they negotiated. The judge doesn't get to reduce charges or enhance charges, but her original charge was aggravated assault, family violence, which would have been a range of 3 to 20. But the state, in its plea bargain, reduced it to the misdemeanor. So it's not gender specific. And in this case, that's what she was charged with, but the state decided to reduce it. So the bail reform that has gone on in Georgia has been twofold. The second most recent change wasn't statewide, it was local, and it was the city of Atlanta, which set aside cash bail, eliminated cash bail for a number of ordinance and misdemeanor offenses so that you would just be given a citation. What the data ended up showing is that we had it was in municipal court, not in superior court, many more failures to appear. So it had an adverse consequence. The bail reform that we've seen at the superior court level has been to reduce the number of offenses for which a judge can enter what is colloquially known as a signature bond. But the legislature has now labeled it unsecured judicial release. And historically, other than the real most serious things like rape or murder, a judge could decide that if you just need to sign this bond paperwork, you don't need to put up any money or anything like that. And the legislature has ratcheted it back. So there are now fewer and fewer offenses for which a judge can issue a signature bond. So bail reform has moved in the opposite direction. And we haven't necessarily seen positive effects there other than that more people stay in jail awaiting disposition of their case. And that makes sense to some in the public if it's an aggravated assault, but a number of the offenses that were turned into cash only, in other words, no signature bond, were very low level offenses like criminal trespass or a theft by shoplifting. And what we've seen is that the jail population has increased because, as those of you who are regular watchers have seen, most of our defendants are indigent. They have appointed counsel, great lawyers, but appointed counsel. And they don't have a lot of money, and so they can't post bond. And so they sit in jail until they can resolve their case, which means we delay the ability to connect them with resources or to get them back to work or something like that. I don't know that that's what the bail reformers had in mind, but that's clearly been the main consequence of eliminating categories of cases where you could issue a signature bond. And Mr. Ray, I think one difference with the plea we just took is that the state did not ask for the Family Violence Intervention Program, which is a lengthy series of courses. I was a little surprised with that, given that it was a domestic situation, sister-in-law on sister-in-law, because we typically see that. But Ms. Smith is newer to handling this stuff, and so it might not have hit her checklist. I can't answer your question about Scandalakis. That's above my pay grade. But Petty Patty, let me look. So that's a great question. So the question is, hey, we watch a trial and we get to hear the verdict, but we might listen to a civil motion. Like next Monday, we've got an interesting civil motion coming in about a fight over the fate of the ballots from the 2020 general election here in Fulton County. And you'll get to hear, if you are tuned in, all the good argument from the excellent lawyers on both sides. But the ruling in the end has to be in writing, some order that I enter that then goes into the docket. That's public, and people have public access to Odyssey, which is our case management system. But if you are far away or not tuned in to getting into Odyssey, then you never hear the end of the story. You hear the lawyers argue and you develop a perspective of, boy, this side should win, the judge better do that. I don't read those comments. I don't have my own place where I put those orders. I sign them, they get e-filed, and they become part of the public record. They are not secret, they are not sealed, and the media finds them, so they're that publicly available. But you'd have to know the case number and all that. So that makes your participation, which is important, a little unfulfilling because you never get to hear the end of things. There has not been a ruling in Singleton yet, but there is often a ruling within just a few weeks in things that aren't as convoluted as the Singleton situation. And they get published. They're just hard to find if you are connecting to things through this medium. Hey, Ms. Brooks. I want to be clear about one more thing, and then I'm going to go off and we'll do this again sometime. Maybe I'll provide some advance notice. I do not read the comments while we're in the midst of things. That would be distracting, and that would be like having someone in court stand up and say, I don't like what's happening right now. So I don't ignore what you all have to say. Maybe after the fact, people look at them, but it wouldn't be appropriate if I was seeing what all of you have to say about how someone is dressed or someone's demeanor or where they have a tattoo on their body. That would be for consumption long after that hearing is done and I've ruled on whatever I need to rule on. Everyone's ready for the pool trial. I've been a judge for 12 and a half years. We have 4-year terms. I was appointed because a judge retired halfway through his term. If there is an opening like that, the governor gets to appoint. If there's an opening because a judge retires at the end of her term or his term, then the electorate decides in Fulton County. And you're up for re-election every 4 years. So I have been on the ballot a couple times, and I'm on the ballot again in May of next year. The lawyers appreciate the live streams. They're allowed to follow them real time. And it is sort of like having, this doesn't happen as much on the criminal side because it's expensive, but for fancy civil trials, they will do the trial in advance. Each side will get a mock jury and they'll make their argument and they'll have lawyers from their same firm play the other side. And they will have a panel of jurors that they've hired, not official jurors, test jurors, who are providing real-time feedback about how things are going. So they'll know, oh, that went well, that didn't go well. And having real-time feedback from members of the public saying that witness wasn't a great witness, allows lawyers to make adjustments if they feel like your stream of comments are reliable. Sometimes lawyers blush based on what you all say, and sometimes they know, like, well, I was dressed appropriately for court. But you definitely are a source of valuable real-time information about how things are going. Again, not for me, but the lawyers are free to follow whatever they want to follow. They can hire jury consultants and trial consultants who sit with them during a trial, and you guys do that for free, often in a maybe slightly less filtered way than a trial consultant. I do my best to keep the lawyers near the microphones, not just for you all, but you're an important constituency. But we often have a witness who is appearing virtually, or there are family members of either the accused or of the deceased, if it's a murder trial, who are watching through Zoom. We give them a link. They can either watch the way you are, or they might get a direct link to the Zoom feed because they're trusted not to mess with the Zoom feed and barge in. And if a lawyer's not near a microphone, then those people can't hear either. It gets a little tricky when a lawyer is in the well speaking directly to the jury. We've got a camera that picks that up, but there's not a microphone there. I have talked with our tech people about installing a microphone on the little shelf that's in front of the jurors, and that would better pick up what the lawyer is saying when she's facing the jury, which means her back is to most of the microphones. But I have not wanted to insist that the lawyers have a handheld mic, so they're like Phil Donahue while they're giving their openings or their closings. And I'm not nosy, I'm just curious. These are real people who appear in here, and I like to learn a little bit about them. The state is saying you should send them to prison, and the defense is saying you shouldn't, and they're not just a case number or a set of facts. And so I find that it helps me by learning a little bit more about who these people are. All right, well, I'm going to roll. No trial this week, but we are set to do the pool retrial. We may do jury selection if I have my way next Tuesday, but I don't ever live stream jury selection because we've got people, and then it's the lawyers being, to use one of your words, nosy, but asking a lot about these potential jurors and whether the case is a good fit for them. And sometimes, especially if it's a sex crime case, these jurors are having to talk about very, very personal situations they went through. And while the courtroom is open, as in someone from the public could come watch it, I don't live stream it. But the whole trial will live stream. And so those of you who are veterans, you've seen pool. This is pool redo, and we'll see what happens this time around. And so either jury selection will be next Tuesday or it'll be December 1. If we can pull off jury selection next Tuesday, then we'll start with opening statements Monday, December 1st at 9 a.m. Eastern Time. You guys have a great holiday. We'll have a few things between now and the start of Thanksgiving. I think there's a bond hearing this afternoon. And like I mentioned, on Monday, that hearing about access to the general election, 2020 general election ballots from Fulton County. But it'll be pretty quiet over the next few days because we were going to be in trial and all those went away. So everyone have a safe Thanksgiving if you are stateside, and we will reconnect when the pool trial starts.
Yeah, I thought we were.
It's like, I told her, just text them.
Yeah. I have to hear anything. I just picked up the discovery, so
Oh,
it finally got, I just haven't gone through everything yet.
The second, I said, love, I
Yeah.
feel like I'm going down by the second.
You gonna trade?
Yeah,
He's shorter.
I heard it was a lot of activity in TV. I was out of town, but I was getting text messages. But I heard it was.
Those sheriffs were not doing a good job of getting the inmates there. You can't rely on those deputies.
I was getting like, and as soon as you call, I was like, I was gonna do that this morning. I'm not telling you, the sheriff will be.
We're good. I wasn't sure if he was here.
Right.
Mr. Abadi, you good to go?
Yes, Judge.
Okay. Good afternoon, Ms. Rivers. Are you ready?
Good afternoon. Yes, I am.
Great. All right. Let's get on the record. This is State versus Chambliss. Mr. Chambliss is here in court with his lawyer and with Ms. Singleton. We have Mr. Abadi here for the state. It's 25 SC 006076. Mr. Chambliss is one of many defendants in the case. We're here to talk about bond, but I want to start before we do bond. Let's get the official appearances on the record. We've got Adam Abadi for the state and on behalf of Mr. Chambliss.
Savannah Smarch,
Can you spell your last name for the record?
SMARCH.
Great, thank you, Ms. March. Discovery, you submitted a hard drive.
Yes,
Have you guys received it back?
yes, about 2 days ago, I think.
Excellent. I'll be bugging that paralegal, but that person, is that person a he?
Yes.
He has been helping me flag who had provided hard drive, and you had, and I need to make sure that they get back to you. So you now have discovery in it, or you at least have whatever's on the hard drive.
Yes.
Okay, excellent. I will update my list. I am determined to move this along, at least on the discovery front, and then we'll see what flows from motions. Bond is the main reason we're here. Mr. Chambliss, I will in a moment listen to Ms. Smarch as she tells me why you ought to have a bond if you don't have one, why it ought to be lowered if you have one and it's too high. I will also hear from Mr. Abadi, and the family members of the deceased have a right to be heard from as well if there's anything they want to say. And it may be there's something you want to say, and Ms. Smarch can say that's a good idea or a bad idea, and you should follow her advice. She's your lawyer. But in the end, I'll let you know whether I'm either going to lower a bond if you have one or set one if you don't have one. So you'll leave knowing that. It's not going to be a secret. That's really all we're doing today. I may hear some from the prosecutor about things you are alleged to have done in the case. That helps give me a little bit of a framework. It's not proof, and you shouldn't panic if Ms. Smarch simply says, I don't know what to say to that, because she just got a hard drive that has a zillion pieces of information on it. And it may be that what I decide today is, based on what I heard from the state, I'm not comfortable setting a bond, but I give Ms. Smarch and her colleague a chance to go over the discovery with you and say, hey, maybe we get together again in 30 days or 20 days, or however much time she needs to look through it. She says, let me give you a more complete picture of what this case is about. And then I'm more comfortable saying a bond makes sense. I don't know. But that's the way it's going to flow. Okay? You got to answer out loud.
Yes, sir.
Okay. Thank you. Ms. Smarch.
Yes, Judge. Oh, do you want us to start?
I do.
I apologize.
That's okay.
So Mr. Chambliss, last week when we were here on the Wednesday, it was his 17th birthday. So he's just been moved. I believe he's in Union City at this time. But we do have a place, if he bonds out, he'll be, I think it's his aunt's house. I don't know if you want that on the record with the live stream, but I do have that.
I don't need it on the record, but tell me a bit about that household, who's there, whether that's where Mr. Chambliss was before.
I don't believe he was living there beforehand, but it's with his aunt and her and uncle, their 4 nieces and nephews, or their children, his 4 nieces and nephews. And it's in Cobb County, that address. I have talked to her on the phone to confirm that as well.
Okay. She has said, yes, my nephew is welcome here. There's room.
Yes, I believe, you've spoken to them as well. Yeah. Yes, and then father is here, Jonathan Chambliss is here in the courtroom supporting him today.
Great.
Mr. Chambliss he's gone through up to the 11th grade. He's working on this GED in the jail.
Where'd you go to high school, Mr. Chambliss?
High school.
Douglas. All the way through however far you got in 11th, but 9 through 11th was all at Douglas?
Yes, and I believe he was also attending church when he was out on bond, or not on bond, before this incident, Judge. But we're asking for bond. I don't believe he has any history. This is the only case, to my knowledge. He does have mom, dad, aunt, and her husband are supporting him. We've been in contact with him. And I know Ms. Singleton has more background for the school and whatnot, but we have also discussed with Mr. Chambliss, he personally has asked to have like a behavioral health assessment and get some work done. So he does want to do that. And we've discussed programs, I believe, if he's released on bond, that we can work on getting him into, as well as backing up him, supporting with the case and his defense for this and this issue. But I don't believe he has any priors. I'm not sure about the school records, but Ms. Singleton can speak to that.
Okay. So he has a place to stay. And Mr. Chambliss, were you living with your aunt back when you got arrested in this case? You would have been, I assume, somewhere near Douglas High School, if that's where you were going. And whose household were you in then?
My mother.
Your mother's? Okay. And your mother and your father have 2 different households? Okay. Ms. Singleton, you've had to explain this probably 100 times to me, but Mr. Chambliss is now older than 17. Well, he's turned 17. What does that mean in terms of your supervision of Mr. Chambliss should he get a bond?
He would still be under my supervision, Your Honor. He would not receive the wraparound services paid for by BJJ, and he would need the county funding.
Okay. What would school look like for Mr. Chambliss? I'm assuming he wouldn't join a school now in November. Would it be an online opportunity, or he'd be living in Cobb? So 2 reasons why Douglas wouldn't work. He might not be welcome back there anyway, but it's mid-year and he doesn't live in that district.
That's correct, Your Honor. He has been expelled from Douglas based on this case. I spoke with the aunt about the Promise Center, understanding that they are in Cobb. And she said that if that were where I thought that he should go, she could make that happen. I spoke with her about the work schedule between her and her husband, as they are the 2 adults that would be in the home, to see how that would work out if he did end up having to do some type of online program at home. My first thought would be to try to get him to go to the Promise Center simply because of the behavioral health assessment specifically. They would be able to do that there, as well as offer any counseling that he would need.
Right.
I do supervise one of the co-defendants that is out, and they are not in that setting, so it would not be an issue of them ever having.
They're not at Promise.
No, they're
Okay.
not. So that would not be a problem concerning this, because I had to take that into consideration with
Right.
the box as well. And I did speak with the aunt and tell her that if that did not work out, or if he were to be granted a bond and the court was not comfortable with the Promise Center idea, which would bring him back into the city each day, then we could look at a GED programs in the area in which she lives, because typically the technical schools in the areas have a GED adult education program. So we can find something GD related that he can go to in person, and if the court isn't comfortable with that, then we can look at online school opportunities.
Okay,
That would make the behavioral health, or if the court wanted something like that to occur, that would make it a little bit more challenging. We would just have to look around and see what we can find.
got it. Okay, thank you. Mr. Abadi,
Good afternoon, Judge.
good afternoon.
I would respectfully request on the state's behalf that.
Oh, hold on one second. Bond, what, we never talked about, I have all these conditions, and then it would be, is it a $10 million bond or a $10,000 bond or a reasonable bond?
Reasonable bond, we would ask, no more than, I would ask for 50 to.
Okay, and I don't know the family's means, and so given the charges, in some people's minds, a reasonable bond could be $1 million, but that's effectively no bond for probably every defendant in the case.
Yes, Judge. I'm not sure what the co-defendants who were released, what their bond was. I don't have access to that, but I would just be asking for reasonable bond since he does not have priors, and we do have a system set up ready to get him to and from court and back in a better path.
Okay, you said one thing I want to follow up on. You said you don't have access, as in right this moment, or do you not have Odyssey? It's not secret.
No, I have one person in my office who has the Fulton Odyssey that I just don't personally.
Okay, everyone siphons off that. Okay, got it. Okay, thank you. I'm sorry, Mr. Body. I just realized I want to focus on your concerns, but I didn't even hear a bond amount, but I got it.
Yes, Judge.
You think no bond?
Yes, and I would bring, I guess the position of the state is that Mr. Chambliss should remain in the custody of Fulton County Sheriff's Department. His role in Mr. Van Arsdale's death was very akin to the prior bond hearing with Unique Jones, as he is the individual who lured the victim in this case to the incident location. He called.
So Ms. Jones is the other, I mean, we have two different decedents in this case. And I think Mr. Byrd is the one defendant who is connected to both.
He's the link, yes, Your Honor.
Okay, and so Ms. Jones, according to the state's perspective, was the one who convinced the young man who died in that situation. That's not Mr. Van Arsdale. Mr. Van Arsdale is the one you're about to tell me. Maybe he has had some connection to Mr. Chambliss.
That's correct.
Okay.
And because of that connection, Mr. Chambliss called him on FaceTime the day of his murder on December 29th of 2024, and set up a drug deal, a marijuana exchange, where Mr. Van Arsdale was going to sell a small amount of marijuana to Mr. Chambliss. There are DMs where Mr. Chambliss and his co-defendants are all, talking about the setup and things of that nature. He goes to the incident location, which is 2693 Washington Street here in Atlanta, Georgia, Fulton County, where he has advised or told the victim to meet him for this drug exchange. And then the other.
From what you've seen in these communications, does Mr. Chambliss set the location or does Mr. Van Arsdale?
Mr. Chambliss is.
Okay, so come meet me at place X.
And once the victim arrives at place X, at that point, the defendant and one of his co-defendants, Mr. Clark, walk to meet the victim. And at that point, it's a melee of shots towards the victim as he's exited his vehicle. I can't tell you who shot him. No firearms were recovered and things of that nature. But what I can tell you is then.
How do you know, what's your basis for saying Mr. Chambliss and Mr. Clark are the ones who walked towards Mr. Van Arsdale and his car?
The statement from Mr. Byrd provides that. And then there's corroborating evidence that would show after this defendant takes the car of the victim, it was a red Honda Pilot, I believe.
Oh, so there's not just that they shoot him, then they take his car?
Yes.
Okay.
He's
I should just listen.
The individual who takes his car, and that's corroborated with the fact you can see him running back from the location of where the car was abandoned to a meeting spot, one of the co-defendants' homes. What I can tell the court is, in addition to that, the defendant on January 6th of this year DMs or through Instagram sends a private message to a co-defendant of his, taking responsibility or bragging about being the one who killed the victim in this case. So that is what I can, in all candor to the court, Mr. Byrd, who made a statement that doesn't necessarily line up with who he thinks fired the fatal shots. But you have this defendant saying that he did that in the DMs for his Instagram.
Is there ballistic information that shows more than one gun was fired at Mr. Van Arsdale?
Preliminarily, yes, Your Honor.
Okay.
Nothing has been verified by the GBI, but there have been several knife hits from this location to other shootings. But on this scene, there is multiple shell casings from different weapons that.
I mean, there's a 9mm and a 3.8.
Yes.
The shell casings show there has to have been more than one gun fired.
That's correct.
Okay.
Based upon all of that, I would submit to the court that he's a danger to the community if released on bond, as well as a risk of intimidating witnesses, as he would have access to be in communication with his co-defendants where he isn't supervised like he is as strictly now. I'd also bring to the court's attention the aunt's house, I believe I heard was in Cobb County. Mr. Van Arsdale's family, that is the area where they live in Cobb County. So I can express their concerns to the court as it relates to the defendant being in an area that they're one safe haven that they feel, they're not at risk or a threat. So based upon that, I would submit to the court that at this time, the defendant should remain in the same status as he is now with no bond. At the appropriate time, I know at least the victim's mother would like to make a statement to the court.
Okay. I meant to ask Ms. Singleton, but I've been interacting with you most recently. You sometimes have this. Do you have any information about whether Mr. Chambliss has a juvenile court history?
I do not. I requested it and I didn't get anything back, which maybe my assumption was that no, he did not. And then I had spoken with Miss Hudson Singleton, who had indicated that I don't believe if he had any, it was very minor, but I don't believe he had any juvenile history. I just knew he had been expelled from school. I did not know it was a result of this situation.
Okay. Ms. Singleton, I should have asked you, any juvenile history?
No.
None. Okay. All right. Yes, Mr. Abadi, I would like to hear from whomever, from Mr. Van Arsdale's family. And if you come up, you can sit right next to Mr. Abadi, please.
Yeah. Good afternoon. My name is Elisa Van Arsdale. It's spelled E-L-I-S-A. Van Arsdale is V-A-N-A-R-S-D-A-L-E. And I am the mother of Darren Lamont Van Arsdale II, who we will now refer to as Monty. That was what he was known as. But I just want to speak really. Last time we spoke, I did not get an opportunity just because of emotions, but I'm hearing about the the suspects and what they are, but my son was 19 years old. He graduated on time from high school in May of 2024.
Where'd he go to high school?
Hillgrove. He went to Hillgrove High School for 3 years and he graduated from Westlake High School his senior year.
Okay, I know Westlake. Where's Hillgrove?
Powder Springs, Cobb County.
Got it.
My son was an amazing, bright light that just affected everybody and infected everybody in such a positive way. He lit up a room when he came in. He was a four-year varsity letter basketball player at 5'6". He could jump through the roof. He was very well known throughout the entire Cobb County, just for personality and athleticism. He did a program when in 11th grade. He did the early entry because he thought he wanted to go into the United States Marine Corps. So he did the early entry program to there and even did the weekend at downtown and then decided, maybe that's not for me. And then he went and did his insurance adjuster's license, just trying to find his way at 19 years old. He also decided he wanted to get into being a athletic personal trainer. So he was very into fitness. But I just want to, just speak to, what he was and what this has done to us as a family. Evil comes in and it comes to rob and steal and destroy, and it has done just that. It has destroyed the foundation of my family. We have 5 children, and it has left me and my husband and my kids shattered into a million pieces. We're trying to put the pieces of the puzzle back together, but obviously that puzzle will never be whole because my son was a big part of it. He was a big part of it. I mean, every family gathering, every family dinner, every family vacation. I mean, every year we did that. And this year we couldn't do it. We just couldn't. We had to celebrate his birthday in September, without him, and just learning to live life without him is just
Would he have turned 20 this September or he would have turned 19?
20.
Okay.
He was 19 at the time of
Yep.
the incident. So I just, we just love that boy so much, and he impacts everybody. It's not just our family because we've been in this community for 26 years. So he was raised in this community and he's a part of the community. So not just us, but the community, teachers, administrators, friends, mates and everything is just affected, so greatly. I mean, we did a celebration for him for his birthday, and I mean, over hundreds of people came out for this celebration. But let me just go on record. I definitely am opposed to any type of bond for Mr. Chambliss here. It is shown that he was the person that made last contact with my son. He was the person that FaceTimed him minutes before he left the home and headed to this location.
Is he, Mr. Chambliss, someone that you or your family were familiar with through Monty?
Nope, never heard of him.
Okay.
Never heard of him.
So whatever connection they had was remote enough. This wasn't like, oh yeah, Chambliss, he's been over here a few times.
Correct.
Okay.
I was not aware of him. We were never even aware of our son going to this part of Atlanta. I mean, this is a surprise and a shock. I don't know how many times he went. I don't know the details. Questions I probably would never get answered, which I wish I could. Like, why? What was the reason? But he was the lure that got my son, to come over there. My son, at the time of his death, he worked at Federal Express. He was actually on his way to work and made this stop and never made it to work and never will make it to work or another sunset or sunrise or another Thanksgiving or another Christmas. So, to have his life taken and then for the suspects to act for some sort of freedom is beyond me. I hear the attorney here say that they don't know the work schedule. I think that's important to know what the schedule of the people where he's going to be going is. Also, like it was stated, it is in Cobb County. We're not just a part of a certain part of Cobb County. There's people all over Cobb County that know my son and, are very distraught and upset about what has happened. So, I definitely ask that there be no bond at all. I mean, a reasonable bond would be 10 million, but there's no price on my son's life. So there's no price of a bond that should be let out so that these people can continue to enjoy what we no longer can enjoy, and like I said, it's just hatred and evil, and I don't want to be lurking around it. And I don't think, as far as, a detriment to the community, I think that it is. I mean, you lured my son to your own community. What more would you do to another community? There's people that live in this community that's lived here for decades, and you're multiple shots and a dead body, a body laying on the ground. I mean, it's just too much to think that you brought that to your own community. Why would I now want to invite you into another community? So, I definitely go on record as saying there's no bond that should be set now or ever. Thank you. I appreciate it. You are entering a complicated time for your family. It's the holidays and Monty won't be there, and you have a real unpleasant anniversary coming up at the end of December. So, refer to it as the angelversary. Yeah. All right. We'll figure out how to honor. I feel for you all, and I appreciate you being here and finding the strength to share that. It's always good to hear from people who are connected with the person who lost his life. Yeah. Thank you. A person that meant a lot to everyone, to a lot of people. I bet. Yeah. That's clear. So thank you. Thank you for hearing me. You're welcome. All right. Mr. Abate, anyone else? Great. Okay. Well, I do want to address the family in one way, and that is that, and I trust either Mr. Abate or the victim advocate has explained to you all that while you feel
you expressed a degree of certainty that Mr. Chambliss did X or Y or Z, I need to treat him with the presumption of innocence that sits upon anyone charged with any crime. So I'm not deciding in whatever I rule today that he did or didn't have a role in what happened. I'm required by law to focus on, number one, is it likely that Mr. Chambliss would show up for court for any future proceedings? That's the dictate from the appellate courts, is the likelihood to reappear. A very, very close second, to me, it ought to be equal, but it's a close second, would be the safety of the community, which is what you were touching on. And I certainly think about that. And then Mr. Abate flagged another factor that I need to weigh, which is any risk that witnesses would be interfered with or intimidated. And intimidate doesn't mean you walk up to them and say, I'm going to get you. Intimidation can mean, hey, you need to tell a slightly different story, or let's all cover for this guy or that guy. And that's something that I need to assess as well. Ms. Smarch, I want to turn back to you as the movant to see if there's anything you want to say to wrap things up. You've heard what Mr. Abate had to say. I'll repeat. That's helpful for me to hear. I don't take it as proven, but it provides a framework. I have found Mr. Abate in particular, but the DA's office in general, to be candid about things. And if Mr. Chambliss's connection was he provided the car that other people drove, he'd say, look, we indicted him, but he provided the car that people rode in. We don't even think he was there. And that's not what I heard. And so while it's not proof of anything yet, it is an indication of interconnectedness that makes me think about this in a different way than if it was his car, and that's the way we link him in. But with that said, anything more you want to add?
Yes, Judge. I mean, I do understand and I sympathize with the family. This is not easy. But I do, as I said, I did just get discovery, so I personally have not gone through everything. I do understand some of what he's saying is listed in the original warrants, but we would like to go through it. So I can't speak on discovery at this time.
I didn't expect that.
But as I said, I believe there are some individuals that are out. He has no history. And I know that there's more steps that are to come in discussions with the state in regards to any alleged interactions. In this case, for Mr. Chambliss specifically, that will be worked on either with or without the bond. I know that it's another step in the process. It's an odd timing for the hearing today based on what I have knowledge-wise for this case, but we do have the family support. We have a system. He does want help. He asked me for the help. So we're working on that together. And I believe with house arrest, keeping him confined, online school, if we need to limit, I mean, of course, there will be no contact. I understand with, any family victims, co-defendants, anything. But we can further limit that if need be with more restrictions. But we just want to get him home and get him out of the jail at 17, Judge.
Okay. Well, I appreciate you sharing that. What I'm going to do is ask, I'm not going to set a bond right now, Mr. Chambliss, but let me explain what's happening. I'm not going to set one in 10 minutes either. I don't want you to think it was that way. It would help me if you could please, Ms. Smarch, send to Ms. Nelson, but copy Mr. Abate. Here's the address we're talking about. And then if you could do the same, Mr. Abate, for the Van Arsdale household. Cobb is big, but it's small at the same time. And so if the two addresses are too close, then it's a non-starter. And then you just need to look for a different location if I'm going to think about setting a bond, because there needs to be a safe and stable location for Mr. Chambliss to go to. That's not where he was when this happened, when this situation arose. And you found one, but it may be that the proximity to the Van Arsdale household doesn't work for reasons I'm sure you appreciate, and that Ms. Van Arsdale articulated very effectively. So I need those addresses. And then number two, I want to give you more time to do what you weren't complaining. I don't mean it in that way, but you observed, like, I got to take Mr. Abate at his word. I haven't had a chance to look through this hard drive. I want you to do that. And you may want to ask for some guidance. Hey, where do I find these private messages in the 82 gigabytes that I got? And they say, go to the directory that says bad news or something, and you can go there. But I am very open to having another discussion about this after you've had a chance to digest the kinds of things that Mr. Bade was referring to. But I'll tell you that based on his representations that Mr. Chambliss not only was aware of what was going on, but was, and this may not have been his word, but sort of boastful or celebratory about his participation in it, I'm not inclined to set a bond. And while I appreciate there would be structure to what you've set up, if we had the county-funded ankle monitor with a curfew that is, it opens up only for work or going to an at-promise center for GED or maybe treatment for behavioral health needs, I'm not quite there yet. But I do want to give you an opportunity to look through discovery where we might come back and say, Judge, actually, we're going to allow in, just for purposes of bond, these 6 pages of exchanges, because I think if you read them all the way through, you will see that that's not the full story. So I'm always open to that. I won't set a deadline for that. You will go through it as you are able, and if it reaches a point where you think we ought to revisit this, I'm always open to that. The other time I'm open to revisiting this denial of bond at this point would be if you are running into the state's not ready. The state doesn't have this. We haven't had that yet. Mr. Hiles worked very hard before he took his leave to have all this information available. But that doesn't mean it's all the information. And so you may look in there and say, wait a minute, there's a police report that says my client gave a statement to the police. It's not in here. And if we're waiting week after week to get your client's statement, then we need to talk about bond again. If any delays are occasioned by the state not being ready or not having, as opposed to you wanting more time, that to me is a crossroads where we need to say, well, we have someone who's presumed innocent, who's 17, sitting in jail, not advancing in any way that's helpful to anyone in the community. And he's stuck there because the state can't find the body cam for this person. Then we would talk about it again. But if discovery is flowing, you file your motions and we're able to move this along, then I'm going to maintain things the way they are. Does that make sense? Okay. Mr. Chambliss, everyone else but you did the talking right now, and that was appropriate. Do you have any questions about anything I said? Okay. What's going to be next for you is time with both your lawyers as they go through this discovery. They may ask me to sign an order that lets them bring a laptop in so you guys can see it. If it's video, if it's paper, they can leave you with some of the paper. Be thoughtful about how much you want. Having discovery in jail is a two-edged sword. It lets you read it and you're going to understand it better, and you'll be able to say, hey, look at page 22. That's real important. But you also, having discovery in jail gets people curious. What do you have there? And it can make life complicated for you. So talk with your lawyer about it before you say, I want a copy of everything. Okay? Ms. Smarch, anything else on behalf of Mr. Chambliss?
No, Judge, you said there's no time limits per se for refiling.
No, not at all. Other than, don't refile tomorrow saying, oh my gosh, it's oppressive conditions. I get it. Union City is not a happy place to be. That part I'm aware of. And so we would reconvene because you have something to add to the conversation we have, not to repeat something we already heard. And what you'd be adding is, let's look at discovery together, or we have been ready to move this forward and the state is stuck somewhere. And my client is ready for trial right now or ready for this motion to suppress, but the state keeps saying we're not ready. Then we should talk about bond again. Okay?
Yes, Judge.
Mr. Abadi, anything else from the state? Okay. Thank you, everyone.
Thank you.
Oh, he can stay. It's a technical question. It's up to you whether you want to hear it. Mr. Blackwell still doesn't have a lawyer. It is not your job to assign lawyers, but he needs one appointed. For a while, Ms. Cabrera's name was attached to it because she's sort of the default person she's not a conflict defender, but you're with GPDC, or am I mistaken?
But East Metro.
I understand, and it won't be you.
Around the corner for me.
And it's not gonna be you, and it's not gonna be Ms. Williams, but who do I need to bug, to get Mr., because that's a place where we're stuck, and that's not on the state.
Joy Walker.
Joy Walker,
Yes.
okay.
She should be able to.
All right, and not Mr. Luemba. I don't
He's
even.
one of our contract attorneys.
Okay.
Our senior.
And he has a defendant, as does Ms. Cabrera, so I think he's done. He sometimes helps with assignments, some contract he has with GPDC, but Joy Walker is who I should,
She handles that Fulton.
okay. I will reach out to her and we'll figure out.
I'll nudge her as well.
Okay. All right, thank you.
Yeah, no problem.
Would you mind spelling your last name for me one more time?
Oh, yeah, it's SMARBH.
And I don't know, you may not have been here, it may have been Ms. Ocom who was here, but Ms. Smarch explained that she and Ms. Williams are kind of tag teaming on Mr. Chambliss.
Yeah, I think I met her through Corey Comer,
Yeah.
another American.
I figured if it was yours.
That's what we do.
Okay.
So. Yes.
Yeah, let me just touch base. But
Hey, Captain Phillips. I was wondering who this big guy sort of leaning over there was. What brings a captain into the courtroom?
Been reassigned, I used to be in field operations.
That's.
At the courthouse, so kind of
Fantastic.
moving around.
Okay.
Learning the ropes.
What will your role be? Sort of supervising the sergeants or?
He's pushing over, I didn't realize how.
Courts, they come, Captain Barry.
You just let me know if there's any way you don't see or me.
Oh, okay.
Learn from him.
Excellent.
Essentially,
What he was doing. Got it.
which I'm still learning.
Sure. No, it's new and you should see the courtrooms and whatever Gordon does, do the opposite and then it will work well.
Yeah.
That's
what I told him.
I opened it, was like, oh, so, yeah.
Good. Yeah.
Yeah.
No, look and learn and listen, and I'm happy to field questions if you want to know. I'm happy to let you know these judges are high maintenance, these judges are low maintenance, but they'll let you guys, they'll let you know all that. Well, that's exciting. Cool so far. All right, well, we'll try to keep it that way.
Yeah.
Welcome aboard.
I have to double check the city on that and then I'll send it to you.
Okay.
Being here is different, executed, so many of you all's orders. They never put a name to a picture.
Right.
That's a piece of paper, signature, do it.
Right, go do these things, and now he's like, oh, that's that person. Good.
Judge, can I be excused?
Yes, sir, thank you.
Thank you.
You saw the email. I don't know when we'll hear from Mr. Miller. I haven't seen anything yet.
I meant to look to see if he had taken a lead and filed it or something.
Yeah, he did, and so, I'm not optimistic, but then we'll just pick a jury on Monday. All right.
Thank you.
Sure. So how long is Captain Barry still here?
I think he'll be the end of the year. It's nervous about a month to the